Okay, good morning, everybody. It's just gone 9:30, so time to resume and continue. Welcome back for those of you who attended on previous days, and welcome along for those of you who haven't attended any of the sessions so far. My name is Matthew Birkinshaw, alongside him is my colleague, Mr. Thomas Bristow, and we're both appointed by the Secretary of State to undertake the examination of the Dacorum local plan. Also in the room today is the Programme Officer, Louise St. John Howe. If you have any questions, queries relating to the documents, the programme, the website, or any of the hearing sessions, please do speak to Louise. Today we're moving on to, well, certainly this morning, look at matter 9 around the natural environment and some of the policies relating to the greenbelt, natural landscapes, etc. Before we get into topics of discussion, I'll ask the Council, first of all, to sort of let us know of any housekeeping matters or any fire and emergency procedures that people need to be aware of whilst they're in the Council building. And then I'll ask you all to introduce yourselves. So we probably use this now. Go around the table if you let me know who you are, if you're acting on behalf of a particular client or a particular group. But really probably key for today is which of the particular policies or issues you're here to talk about this morning. Okay, thank you, Mr. Layden.
Thank you, sir. Good morning, everyone. My name is Ronan Layden. I'm Head of Strategic Planning at the Dacorum Borough Council. I'm accompanied on my right by Craig Howell-Williams of Francis Taylor Building, KC, who's representing the council, and to my left is Claire Covington, Assistant Manager in the Planning Policy Team, and further to my left is Keely Mitchell, who is Principal Planning Officer in the Planning Policy Team. With regards to housekeeping, we're not expecting a fire alarm today. The fire evacuation alarm in the forum is a voice alarm system rather than a traditional siren, although within the council chambers you do hear both. The alarm will announce that the building must be evacuated due to an emergency. On hearing the fire alarm, everyone must immediately leave the building by the nearest available route. There's a staircase on the right as you leave the council chambers, or to the left and past the lifts as an alternative option. Please follow the fire marshal in that event. If in the event of a fire you would need assistance in using the stairs, please make reception aware. The main assembly point is at Market Square, which, for those who do not know where that is, if you leave the council buildings by the main entrance and exit, turn right, cross the pedestrian crossing lights, and a short 2-minute walk along the main street will take you to the Market Square. Toilets are located to the left after the lifts and also by the cafe on the ground floor. The hearing sessions are being live streamed and recorded to be made available after the sessions. Please be aware and leave the council chambers if you do not wish to be filmed. Thank you, sirs.
Yeah, Anthony Harbridge, Berkhamsted Residents Action Group. I think basically all the policies that affect Berkhamsted.
Hugh Siegel, Berkhamsted Residents Action Group, ditto. Anything to do with the Greenbelt.
Richard Turnbull, Planning Advisor for Chiltern Society, the Greenbelt and the natural environment policies.
Good morning, Matt Thompson from the Chilterns Conservation Board. Here focusing mainly on policy at NE1, but also able to give national landscape perspectives on the other policies if called upon.
Morning, and MB from Canal and River Trust, Area Planner, we're predominantly for policy NE8.
Good morning, sir. It's David Churchill of Carter Jonas, representing Crowd Ace Homes Limited, and principally interested in policies NE1 and NE5.
Morning, sir. Tony Clements from Nexus Planning, representing Crest Nicholson. Principal interest today, policies NE4, 5 and 6.
Okay, thank you all. Okay, as we've done on previous sessions, we're sort of looking at some of the detail of these policies now. So we'll probably spend a lot of time looking at the actual policy wording. Again, if you wish to sort of engage in debate and you've made representations on a particular policy, just let me know and we'll bring you into discussion at the appropriate point. So, turning to matters, issues and questions then, the first question, it was a point of clarification really. Are there any alterations proposed to the Greenbelt boundary which do not form part of the site allocations? And I think in summary, and sort of turn to the council here, Mr. Layden, perhaps, I think you said that there's 3 alterations that don't form part of site allocations. A, is that correct? And B, do you just want to quickly run through what they are and the reasons why there needs to be a boundary change?
Thank you, sirs. Yes, you're correct. There are 3 alterations. It's set out within our response, paragraph 1.1.1. The first one is Rectory Farm, Kings Langley. It was fleetingly referenced, I think, in the earlier hearing sessions. That site is within the Greenbelt and did receive planning permission and is now under construction. So it does form part of our commitments and is currently being progressed. So we feel that, in light of that, it's at the time that the plan was finalised, it was logical and rational to look to revise the boundary to exclude that from the Greenbelt. Number 2 is Grove Hill Playing Fields at Hemel Hempstead, noting that it is adjacent to HM01 North Hemel. So this is ultimately playing fields on the current edge of Hemel Hempstead. Through the allocation of HM01 and its release, this land, ultimately, it would be logical for us to exclude this land also. Otherwise, it would be an island parcel of Greenbelt standing in isolation. And similarly, for Pound Meadow at Tring, which is adjacent to TR01 Dunsley Farm, a similar scenario there that comprises principally of some sports pitches and recreational space. The allocation of TR01 removes the Greenbelt from TR01. It would leave an island parcel in isolation of Greenbelt. So logically, we feel it's appropriate to make those amendments also. Beyond that, currently, there is no further alteration suggested.
Okay, and that was a point of clarification really for ourselves, because obviously we have to find those exceptional circumstances for all the boundary changes, even those sort of minor sort of tidying up of the sort of maps, etc. Any comments on that? It was really a question for the council, Mr. Seagull.
Thank you, sir. Clarification, really. Mr. Layden yesterday referred to Berkhamsted School and Haresfoot. They have a site, Haslam Playing Fields on Shooters Way, which I think is BK01, BK03. This is designated for 100 homes and some green space. To facilitate that development, the developer is proposing to take land from the Greenbelt at a more remote site. I can't give you the address, but it's Haresfoot, where they will build a sports facilities, presumably changing facilities, running track, other sports facilities, principally for the school. I guess there may well be some community use, but it is not a community facility, and there will be parking. So that would be a piece of land, which, as I understand it, is currently in the Greenbelt. We'll propose, if this happens, to come out of the Greenbelt, and you have the interesting situation where you've got a piece of Greenbelt in the town, which is going to be built on, and then you've got another piece of Greenbelt outside the town, which is also going to be built on. So quite, in very simple terms, Berkhamsted School have a playing field, keep a playing field. Why take 2 pieces of land effectively out of the Greenbelt? And so therefore, clarification, is this another piece that is going out and therefore it comes under question 1, apart from obviously in 2 weeks' time, there will be a discussion on this site in more detail. Thank you.
Just briefly on that, Ms. Layden, just in terms of the actual sort of maps things, I'm mindful that there will be a sort of wider discussion around, the settlement and the allocations there.
I'll just pass on to Ms. Mitchell to respond on this one.
It's a fairly quick answer. The site proposed for the replacement sports pitches at the Haresfoot campus BK04 is to be retained within the Greenbelt.
Okay. Any other questions just on the boundaries of sites that aren't part of allocations then? Any boundaries that are incorrect, people think? Okay, we'll move on.
Sorry.
Yeah.
I'm sorry. On that response from Mr. Mitchell, I mean, could you actually clarify for me what that means? That you have a piece of Greenbelt, which is Greenbelt, nothing on it. It is going to be built on. All right, not for houses, but it's going to be green. It's going to be built on. How does that continue to be in the Greenbelt?
Maybe a good question to ask would be, So this is, yeah, BK03, BK04 that we're talking about, the allocations. I think I'm right in saying, is Haslam playing fields, that's BK03, that's currently in the green belt. And so is it effectively the council's intention that, well, there was playing fields with facilities there, and this is essentially replicating that or improving upon it, recognizing that that was previously in the green belt and would effectively stay in the green belt?
So BK03, Haslam playing fields, is recommended to be released from the green belt and developed for 100 units. Then the relocated playing fields at BK04 is to be retained as green belt on the basis that the provision of appropriate facilities for outdoor sport is not in appropriate use.
I think I can understand, Mr. Siegel, where you're coming from, but I suppose the logical secondary argument would be, well, BK, and we are straying into Berkhamsted, so I'll just say this and then stop. The logical following on concern, that's not a phrase, but it's what I've said, would be that BK04 would in time also potentially become a candidate for release from the Greenbelt in the same rationale that Haslam playing fields would become a candidate. What would the council say to that?
I mean, if that were to happen, then we'd have to follow national planning policy with regards to finding alternative location for the relocated sports pitches, which are being moved to BK04. So that would go through the standard site selection process. But just to confirm, that's not something that is being suggested at all by the site promoter or by the council.
That's helpful for my understanding. Thank you.
Let's move on. So we're straight into looking at those allocations and how they all piece together. And I'd rather have that debate when we've got everybody here. Okay. Question 2, is the plan clear how Greenbelt policy, or well, I guess another way of phrasing this is, does the plan include any Greenbelt policy? So we're a developer, we've got a site in the Greenbelt, we want to build something. Where do we go in the local plan to assess that proposal?
Thank you, sirs. And set out in our response to this question, and again, we have had a short discussion on this already. Our position is that we don't think it's necessary, but we have been listening to this, and as part of our response, we have put forward a suggested modification. Currently, suggested to sit within SS1, the spatial strategy. That talks some modifications there. A, to make it more clear what small villages are inset, firstly, or sorry.
Just double check that everyone has their, doesn't have a mobile hotspot on, because sometimes that interferes. So might be prudent as well to put your phone to an aircraft mode, just to avoid any interference. Let's give that another go, Mr. Lane.
Let's try that. Thank you. So the small villages, we are proposing, being very clear that there are a number of those that are washed over by the Greenbelt, and being clear on that. And then we are including an additional requirement and heading on the Greenbelt, which basically says the principle of development in the Greenbelt will be determined in accordance with national policy. And just that is sought to square that circle. I think, A, we are very, very mindful. We do not want to repeat national policy. We think national policy does quite a lot in determining proposals in the Greenbelt. Nevertheless, in light of the discussions, we felt that might be appropriate. This is possibly one way of doing it, and the team has considered whether it is more appropriate to have it as a standalone policy, just to be maybe more explicitly clear. At the same time, it's relatively minor wording just to ensure that people are aware of it.
If you had a development within, let's say, within Berkhamsted, Tring or Hell Hampstead, what's the policy that you'd go to sort of that sets out that essentially you're within the sort of urban area, the principle of development presumably is acceptable? Do you have such a policy? Is that SS1?
Not specifically. It is considered in line with each of the strategic policies. So the starting policy under each of the chapters. So for housing, you would have, if I can direct you to strategic policy H1, which is on page 42 and 43. And point 3 there, it talks about the principle of housing development will be supported in accordance with the strategic policy SA1, relevant site allocations presented in chapter 12 within the built up area of the 6 main settlements as defined by the settlement boundaries and through limited infill schemes within the listed small villages, unless the development is on land allocated for an alternative use.
Okay, and then that takes us back to SS1, and then the small villages, Jimmerfield, etc. They're all washed over, are they? Yeah.
Not all of them, and within our response, we do seek to, by means of using an asterisk, highlight and a footnote, highlight of those ones, which ones are washed over and which ones are not. The intention to make that more effective and more clear with regards to those that are washed over by the Greenbelt.
Okay, so it probably goes back to a sort of phrase which we've used before, which is ultimately it's your plan, where probably I don't think we mind where it goes, but I think it needs to go somewhere is basically the crux of the argument. I think you're right. I think there needs to be something in there. It could sit within SS1, you know, some additional wording with some associated supporting text, maybe just making it clear, especially around the washed over villages. Because I don't think that's referred to. Under criterion 5 then, would there be any conflict between villages that are washed over and those which are not? So criteria, I'm just thinking if you sort of put asterisks next to them, referred to them as washed over. So limited infill, okay, consistent with national planning policy. Assessment shows it's within the built-up area of the village. Comprises a gap in an otherwise clearly identified built-up frontage. So if you did incorporate into SS1, do you think that would work? Do you think there's any conflict with any of the other criteria? I'm just trying to think that if you try and sort of put it in SS1, would there be any internal conflict? But I don't think there would be.
I don't believe so. As I said, we've considered multiple options for this in terms of how we would do that. I think just being explicitly clear within the spatial strategy, which ones are washed over and which ones are not. Inevitably, I think our strategy for the smaller villages is broadly consistent, whether they are within the Greenbelt or not. But we do kind of recognise that there may be opportunities for those that are not washed over, or those that maybe sit outside of the Greenbelt, you know, opportunities that through other policies in the plan, or indeed even exception sites, you know, there's still, you know, other components that would allow exceptionally for other developments to come forward. I hope that's helpful. We thought about it. Again, we will take it away. We believe we'll take the comments that you do feel is necessary. We will look to probably include modifications in the plan. We'll have another look at it just to make sure there is no more potential conflicts.
Fantastic. And I'm going to plagiarise one comment from Mr. Churchill in a second. But before I do, we talked yesterday, I think it was, about general employment areas in Dunsfield. Have I got that all right? Maybe I'm thinking of another plan. Anyway, we talked about 2 general employment areas that are within the Greenbelt and an airfield where there's filming going on that is washed over by the Greenbelt. I think if you're going through that process of sort of defining what's washed over, what's inset, it would be useful to make reference to those as well, whether it's there in whatever concoction of Greenbelt policy and SS1 or elsewhere. Just making that clear, I think, would be really useful for everyone. And the point, I believe it was Mr. Churchill on behalf of CrowdAce made, is that if the definition of Greenbelt in the glossary, now this may be a fairly esoteric point, but that is there as an area of open land where strict planning controls apply in order in particular to check the further growth of a large built-up area. It is designated in the development plan. Now, I appreciate that the glossary is trying to summarize what is a very complicated topic, but I would just, I don't know, I think that needs a little bit of revision, or just to make clear that the glossary is providing a, I don't know, a summary definition of those terms, because, you know, we could say that that elevates one particular purpose of the Greenbelt to check the further growth of settlements. It elevates that relative to others. So I'm sure, well, I hope I'm making sense on that, but yeah, Mr. Layden.
Absolutely fine. I think the glossary does need a review in any case. Parts of it, I think it's long, it's lengthy, but I think where it should be consistent with national policy and the definitions set within that, it probably just needs to be very clear. See the NPPF definition.
Comments, questions on that? Then I think obviously it's a fairly sort of clear direction. I think it's points come in a few representations. Again, there's no need to repeat national planning policy, but I think for effectiveness, the plan just needs to be clear so people know. Okay, moving on. So moving on, question 3 was around NE1. I'll just turn that up. Okay, so again, this is really sort of similar theme around the policies, whether or not the wording is clear, effective, justified, consistent with national planning policy. Again, Ms. Layden, any suggested modifications here?
Yes, in our hearing statement to matter 9, issue 2, issue 1, question 3, we've set out in paragraph 1.3.12 and 1.3.13 a number of areas where we think the plan would benefit from clarity. This relates to paragraph 6.1 and 6.4, where we discuss figure 6 that shows Dacorum's 2 principal landscape types, the Chilterns National Character Area and Bedfordshire and Cambridgeshire Claylands. We think it would benefit from adding National Character Area into there. And then in 6.4, we refer to a more detailed landscape assessment. And again, to provide clarity, we've suggested adding a footnote that this is the landscape character assessment for Dacorum supplementary planning guidance. And then in paragraph 1.313, in policy NE14, we refer again to the Dacorum landscape character assessment guidance, but we there say it's a supplementary planning document when it isn't its guidance. So we've suggested a change there and to delete the further advice contained within the Hertfordshire Historic Environment Record, as that appeared to be ambiguous as to what that guidance might be.
When we, and yeah, I think that's their points of clarity. When we look at the actual policy then, a couple of points that Mr. Bristol and I have picked up on that sort of jump out. The first is a sort of question really. Development proposals located within the Chilterns National Landscape or affecting its setting will be expected to, and then you've got A to C. What's the justification for the test principally in A for developments that may affect the setting of the national landscape, i.e. outside of the national landscape?
We've explained this within our hearing statement in paragraph 1.37, that applying the criteria to the setting of the children's national landscape is appropriate. And we've set out the elements within national guidance which refer to the setting. I can run through those if that would be helpful. So paragraph 182 of the framework contains that development within their designated area setting should be sensitively located and designed to avoid or minimise adverse impacts on the designed areas, designated areas. Section 85 of the Crow Act that states that the general duty of public bodies applies when in exercising or performing any functions in relation to or so as to affect land in an area of outstanding natural beauty in England, and therefore has the effect element. And the guidance for relevant authorities on seeking to further the purposes of protected landscape issued by DEFRA in December 2024 clarifies that for the setting of protected landscapes, the duty also applies to functions undertaken outside of the designated boundary which affects land within the protected landscape, and natural beauty, special qualities and key characteristics can be highly dependent on the contribution provided by the setting of a protected landscape. Aspects such as tranquility, dark skies, a sense of remoteness, wildness, cultural heritage, or long views from and into the protected landscape may draw upon the landscape character and quality of the setting.
We're not suggesting that setting isn't important, and clearly it is. But is the test for something within the national landscape not different to the test for something outside of it? Because that's what the NPPF says. The NPPF makes a distinction between development within and development affecting the setting, does it not?
You are correct, sir, on that, yes. Again, we've developed these policies in consultation with key statutory bodies, Natural England. We've also had regard to representations received. I understand that point. I don't think there's anything there that, I think you have to take it in the context of what national policy says initially, and that we still have to be consistent with national policy, and that's still material. And whether, I'm just trying to understand how that could, in theory, be broken down. I don't think there's anything there. I think there's 3 points there, and it's meeting the aims of the statutory. So when you talk about the special qualities, you know, how that applies, whether you're within or in the setting of, is relevant. The distinctive character, etc. And then point B is meeting the aims of the statutory National Landscape Management Plan. Again, that's got material relative to within and its setting. And again, comply with Chiltern's Building Design Guide. So it's how it's applied. I don't, in terms of that, it's, you know, those arms, I don't think it's really a matter of effectiveness or soundness issue on this. I understand what national policy is and its distinction, but in terms of those particular requirements, you know, it's got to be applied appropriate to those particular criteria.
Okay, anybody got any views on this? Oh, yeah.
Thank you, sir. I've got some points I'd like to make sort of more broadly about the policy, but in regard to that particular question, I think this is where we've got some sort of minor discrepancies, if you like, in the national planning policy framework between what the legislation is requiring and what national planning policy says at the moment. And that always gives us and lawyers a lot of when it keeps us off the streets. I think the key thing is that the requirements, the legal requirements, are that we're trying to, we're seeking to further the purposes of conserving and enhancing the natural beauty of the landscape in relation to, in this in this case, development proposals within or affecting the national landscape. So that includes development proposals in the setting. So the legal requirement is the same, but as you say, the national planning policy framework requirement is slightly different. And this is why we raised, in relation to the more strategic points and the site allocations, the question of the new policy, relatively new policy, at the end of current paragraph 189 of the MPPF about development within the setting should be sensitively located and designed to avoid or minimize adverse impacts. So there's a policy distinction that you're limiting development within the national landscape, but being careful about development within the setting. So there is a slight difference. And in a way, that distinction does kind of support the legislation, because you're thinking about how, what the impacts are going to be on the natural beauty of the national landscape, directly within the national landscape, but indirectly in its setting. I hope that makes some kind of sense. But I think in relation to what the council has said, because the policy in the local plan refers back to the application of national planning policy, it has, I think it has the right balance, the right kind of impact, because it's something you deal with on a case-by-case basis. That, you know, sometimes the impact of a proposal in the setting can be greater than the impact of a similar proposal within the national landscape, depending on what the impacts are. So I think it's appropriate to have that kind of equivalence in the policy itself.
While Mr. Birkinshaw's thinking, and thank you, while you're on the line, the legislative duty 85 is seek to. That's the phrase that's used, as I understand it. Seek to. Is there any rub, in your view, between policy NE1 that says criteria 2 will be expected to further the conservation enhancement, as opposed to seek to? I may be splitting hairs, quite frankly, but I just wondered if you're, with your kind of expertise, there's any distinction between the two phrases in your view, anything material. And I suppose this is one general thought, which you might want to comment on as well. Policy NE1 is prefaced by all development shall help conserve, restore, or enhance the prevailing quality, character, condition of Dacorum's natural and historic landscape. So it's a broader policy about landscape in general, and then it's got a specific element. I don't know if you have come across, or if you have any views as to whether that all-encompassing, all development is the right position from your perspective, as some development may have no impact whatsoever on landscape terms. But if you've got any comments on those two sort of points in terms of effectiveness, that'll be very useful.
Yes, in terms of the difference between the use of seek to and expect, I think the starting point for that is that the Section 85 duty is a duty that applies to decision makers, not to proposals. So in a way, it doesn't fit comfortably within a reference to Section 85 duty within a planning policy. It doesn't sit comfortably for me. It's very useful to mention the Section 85 duty in a local plan just to remind people, but it's not something that the proposal itself needs to consider. It's for the decision maker to seek to further the purpose of conserving and enhancing natural beauty. So the proposal should be expected to conserve and enhance the natural beauty of the landscape. And then the decision maker will need to go through a process of testing that against the duty. Well, testing their decision against the duty rather than testing the proposal against planning policy.
Thank you. That's very, very useful. Yeah, I mean, possibly the second point was a more general point for the council, but if you did have any views on, I mean, criteria 1 strikes me as almost putting all development, wherever it's located, on a similar footing to development that may affect the Chilterns National Landscape, because there's a very clear requirement: all development shall help conserve, restore, or enhance, which is quite a high bar. And I was just wondering if you had any thoughts about sort of the relationship of that provision to provisions in terms of the national landscape. But you may not.
And no, I do, surprisingly. I mean, this is, I'll come back, as I said, I've got some general comments that I'd like to make, but on reflection, the overall policy, I think, as I think you're suggesting, sir, conflates two different things. There's an ambition, an aspiration, if you like, to make sure that all development respects the, as it says here, the quality, character, condition of the natural and historic environment across the whole of Dacorum Borough, which is good. You know, that supports a wide range of MPPF policies, and we strongly support that approach. But as you say, it's a different bar should be applied within the national landscape, and we would, on reflection, suggest that there should be two policies here: one for general landscape character and how you might consider, as it says, all development in all parts of the borough, and one specifically for the national landscape and its setting. And the policy could be divided, I think, basically. Points 1 and 4 are the general landscape policy, and points 2 and 3 are the Children's National Landscape policy.
That's helpful. You've come on to criterion 4 as well, because there is then a return, isn't there, to a general landscape character area, and presumably everywhere in Dacorum is within a particular landscape character area, if it's a national landscape area, if it's a locally defined one. So yes, let me now think about that. I know we've got Mr. Turnbull next to you, but I'll hand back to Mr. Book.
I think just on that point, having thought about it, you can see the council's case that that part 2 is really directing you to the relevant parts of national planning policy and legislation. So we can probably agree that. I think in terms of split out, I certainly don't want to get into any more policies. Again, I think there's enough policies here. What you could do is, and I'll sort of put this to the council, it's their plan at the end of the day, you could rearrange policy NE1. So you have sort of criterion 1 and 4 first, which is a sort of, these are all development proposals, as Dr. Thompson said, it's about promoting good design, etc., etc. And then a break, and then you're into within the national landscape or proposals accepted in its setting, you do this, and there's a clear distinction there. So I think that'd be fairly easy, and would probably, we could support that for effectiveness, but leave it with the council. Mr. Turnbull.
I think we're getting to where I was thinking, because I agreed with Mr. Thompson about splitting the two areas up, because that first statement, conserve, restore or enhance, that doesn't cover national landscapes, because national landscapes are conserve and enhance. So when someone's reading that policy from the off, they're thinking all development only needs to do either conserve, restore or enhance. But that's not the case, so some clarity in that policy is required. And I think if you're not looking at more policies, then clear definition within, as Mr. Birkinshaw has just said, start with the general, then move on to the specific about the national landscape.
No, I'm quite happy with that, and I think it's sensible. Yeah, we'll take that away and we'll consider that. Thank you.
We'll look at some of the other requirements then, and I know Dr. Thompson wants to make some points as well. Just quickly go through some of the points that we have noted. There was the Chilterns Building Design Guide, and again, I think you know where I'm going to go with that one, just in terms of, you know, sort of requiring compliance with guidance. I want to spend a bit of time looking at criterion 3. So major development will only be permitted in exceptional circumstances, and this is sort of where we stray into sort of compliance with national planning policy. It is appropriate to the economic, social and environmental well-being of the Chilterns national landscape. What does that mean, and how is that consistent with the NPPF?
Sorry, sir, can you repeat the question?
Yeah, so we're talking about criterion 3. This is your sort of major development permitted in exceptional circumstances, which takes us to the reflecting national planning policy. It was the first criterion. It says it must be appropriate to the economic, social and environmental well-being of the Chilterns national landscape. What does that mean? How would that be determined? Is it consistent with national planning policy?
I think that's probably something that has evolved over a period of time and taking account of consultation and feedback. You know, understand that perhaps it's not very effective, but maybe Mr. Thompson, Dr. Thompson may be able to contribute towards that. As I said, policy is informed through consultation, engagement and feedback. We got positive responses from people like Natural England through Reg 19 saying it's a very strong policy as a whole, but perhaps it may be helpful if Dr. Thompson wishes to come in on this.
Thank you, Mr. Leyden. Thank you, sirs. This is a kind of mea culpa moment. The Chilterns Conservation Board has promoted a model national landscape, AONB policy, for a number of years, and so the wording used there is part of that model policy. Now that this is one of the things that I was saying. I wanted to say as a general point that the model policy is currently under review. We were working on a review of that policy, and then the National Planning Policy Framework has come under review itself, so we haven't progressed that. But also, we are considering how all of these things need to fit together in terms of what we're learning from the fallout, if you like, the case law and other major decisions that have come about in relation to the Protected Landscapes duties that came in with the Levelling Up and Regeneration Act. So for landscape policy, we're in a rather fast-paced environment, which we're not used to. And as I say, we're working on reviewing that model policy. The particular text that we're talking about at the moment relating to economic, social, environmental well-being and the understanding and enjoyment of the area is taken from the some of the legal duties that apply to conservation boards, which, as you may remember, set up by Parliament at the request of local authorities to do the work of conserving and enhancing national landscapes on behalf of our host local authorities. Those duties include a duty to have regard to the economic, social and environmental well-being of the area. But our current consideration of that particular wording of the policy is that virtually any development at the moment can be argued to be beneficial to the economic, social and or environmental well-being of an area, And what it's meant to be getting at here is that the development is appropriate to the purpose of conserving and enhancing the national landscape. And that's, so this is one of the areas we're trying to get to the bottom of. In terms of the general question about the whole of that section 3 of the policy, our reflection on that, because it is worded slightly differently from our model policy, but as Mr. Layden says, there's a kind of a negotiation that goes on, not just between us and the council, but also between other stakeholders in the plan, and so you end up with a slightly different, sometimes better version of the policy than we would promote. But on reflection, we don't think that section 3 is in accordance with the kind of exceptions tests within the MPPF as it's currently worded. And I think we would prefer to have it just refer back to the MPPF directly rather than defining its own exceptional circumstances.
Thanks, Sarah. I mean, absolutely happy to take that into account. Just a point of clarity, just to go back on myself shortly, a short moment ago, our response to question 4 did set out our rationale for why it was there. Paragraph 1.4.5, we note the criterion, this particular criterion details what would be in the public interest within the chosen national landscape. And it's about that test. And in light of that, you know, that's why it was included. But if the preference and recognizing everything Dr. Thompson has said on this, you know, we're more than happy to go in and consider referring more directly to the framework.
Yeah, I tend to agree. It's very difficult for local councils because you want to, obviously it's your plan, you want to set out, you know, sort of locally specific policies, but where there is that tension and conflict with the MPPF, you end up in a sort of week-long public inquiry arguing what the differences are. And it's not really within anyone's interest because ultimately, you know, what the policy is trying to do is, as it says further up, you know, it's all things that LURA says and the MPPF says. So I'd take it away. Almost like the green belt, really. You could just refer directly to national planning policy. Might be the easiest way of doing it. Any comments on that? No. Mr. Thompson, any other parts? Because there are questions, and let's say I've got a couple. We've got the other questions around sort of the other development proposals, but in terms of the criteria where we're referring to development proposals in the national landscape or affecting its setting, was there anything else in policy NE1 you wanted to raise?
There is, so thank you again very much. And this is all, as I say, coming out of this consideration that we're having following the application of the Protected Landscapes Duty. There are, I think, three relatively minor wording changes that we would seek. The first is that in point 2, where it talks of development affecting its setting, we would suggest instead that it should be development within the setting, because a development that affects its setting could be well outside the setting, and that seems a bit, the setting itself, that seems a bit, and I think the Section 85 duty sort of clarifies that it's development within the setting. And in a way, the setting is defined by where proposals would have an impact on the landscape. So that would be the first one. The second, in point 2A, we would ask that the words, and this again comes from our own model policy, so I am sorry, we would ask that the words special qualities are replaced by with natural beauty, because that's what we're seeking to conserve and enhance. The special qualities are defined in the management plan and describe the distinctiveness of the area and contribute to its natural beauty, but they don't have to be present in the land for that land to have natural beauty. Finally, and it's just a type note in what's currently footnote 11, it should say designated, not designed. The designated landscape, not the designed landscape, although we are big fans of designed landscapes as well. Thank you, sirs.
So two changes there, Ms. Loden. Effectively setting to within setting, again, that would be consistent with MPPF as well. The second point, special qualities. I think you've got a footnote here as well. So special qualities, Mr. Thompson, I think, did you say you referred to natural beauty or did you refer to landscape and scenic beauty?
Well, we say natural beauty. Landscape and scenic beauty is the wording that I think is currently used in the NPPF. And I think that's been carried forward into the revised NPPF as well. And I think there's questions about whether it's more appropriate to use landscape and scenic beauty in the policy, but all the legislation refers to natural beauty. But there's there's a difficulty because the meaning of natural beauty is contested, and landscape and scenic beauty seems to hold more meaning for people. So I would be happy to go with landscape and scenic beauty to be consistent with the MPPF. I would also be happy to go with natural beauty to be consistent with the legislation. But I would leave that to your wisdom and all the councils.
I'm happy for you to say it that way if you want to, Ms. Loden. Obviously, tests of soundness do relate to consistency with the national planning policy frameworks. That's probably the sort of the side of the fence that we would lean on, just because that's what we're here to determine, tests of soundness. So both of those changes we could recommend for consistency with the MPPF. Any views, comments, objections on Mr. Thompson's points?
Nothing substantial, sir. I think we'll just take them away. Appreciate the feedback. Thank you.
As I said, I think they're things that we could easily recommend just for consistency with national planning policy. Any others that you wanted to touch upon? No. Quite a few changes there, as we've talked, sort of tidying up wording, consistency with national planning policy. We've talked about sort of splitting of the policies. So we've got this sort of all-encompassing, all development proposals, good design, character, etc. This is where probably points 4 and 5 come into play then. One of the points that has been raised was around the requirement for LVIAs. So landscape visual impact assessment, prepared in accordance with the latest guidance, and again, you know what to do there, must be submitted for all major development located outside of a settlement. Just talk me through why it's necessary for this sort of blanket requirement for LVIAs for all major development, regardless of sort of where it is in its context.
Yes, as we've explained in our response to matter 9, issue 1, question 5, we feel that proposals for major development outside the settlement areas have the potential to significantly impact the character of the surrounding landscape and views and visual amenity. And the countryside is a particularly attractive area of the borough, which is important for its natural and historic landscape and may be potentially sensitive to development impacts. And therefore, for those reasons, we feel that it's needed.
In some of the allocations, I believe we touched on this for the Hemel and Tring sites, there are requirements specifically for project level LVIAs. So TRO1, TRO3. So it's because by the time the plan's adopted, the allocated sites would technically form part of the settlement areas. Yeah.
So if I'm an allocated site, obviously, as it stands outside of the settlement boundary, plan's adopted, I don't have an LVIA requirement in my policy, so therefore Part 5 doesn't apply.
And then that's why for the sites where the healer or the landscape evidence has raised potential landscape sensitivity to the setting of the national landscape, we've included that site-specific requirement for those areas.
This is essentially windfall sites then, potentially. Other than the site allocations, this is something for windfall proposals. Yeah. Okay. Okay. Well, come on to any reps on that. The second part, all development 3 stories or higher above ground located within Chilterns National Landscape. What's the justification for that? And would it not be caught by Part A anyway?
These thresholds were set, as we consider it, sets a clear threshold for when the requirement would be caught. It reflects that much of Dacorum is 2-storey development, and therefore 3-storey development may result in further impacts, and was a proportionate approach to undertake. I'm aware that there are other alternatives being suggested, which are within DP5 of the Chilterns National Landscape Management Plan, and also that there are alternatives used by other LPAs which talk about development that might be significantly higher or have a significant impact. We felt that it was better to be clear about the likely types of development which would cause that impact rather than having a discussion about relative merits. I think it's also important to note that the policy as a whole provides protection, and there are further criterion regarding landscape character areas which also would come into play and help protect the countryside.
Thank you. I think that'll have to be my first and last because I've just lost my Toblerone. Yes, the point that we've raised is in relation to criterion 5A. And our concern in this instance is, well, you'll be well aware that there are 2 fundamental approaches. There's the LVA and the LVIA. Typically, when we are preparing a planning application for a proposal, one would expect to prepare an LVIA for an EIA scale development rather than a major development. And the reason we say that is because major development, you'll obviously be aware, not only the DMPO, but also this plan defines as any scheme delivering 10 or more units, 1,000 square metres, which in reality I understand to some people will be major, but in the industry, these are not major developments. So in seeking to require an LVIA in all instances of major development, we would suggest that that's unnecessary, just as a case in point. But in reality, it's also burdensome to applicants, to the public who may wish to review these documents, and indeed to the council in putting the resource to respond to those documents. So our position is very clear. It's unnecessary, it's burdensome, and should be deleted.
Thank you, sirs. There's lots to cover here. I think the first thing to note, as Mr. Churchill just said, there's this distinction between LVIA and LVA. and the simpler landscape and visual assessment, I think that's what it stands for, is more appropriate to a lot of the kinds of developments that we're looking at here. And another of our concerns about this part of the policy was that it uses the term major development, and it's not clear whether that's referring to major development as normally defined or major development in the national landscape under the footnote in the current MPPF. So there's a little bit of confusion there. The final thing to note is that the children's management plan has recently been revised, and the policy DP5, which relates to LVIAs, or I think used to just relate to LVIAs, now relates to both. It is a bit more helpful in that regard, and we did think that the criteria for when LVIAs should be used here was a little bit ambitious, I think, in terms of how it relates to the Landscape Institute's advice. So I think LVIAs should only be required for EIA development and for developments that would cause a significant adverse effect on the natural beauty of a protected landscape. So there is I think that there is a kind of feeling that it might be a bit of a overly stringent requirement for the full LVIA test.
So we just for those who maybe weren't here, we talked about this under the site allocations, and there's a couple of instances on site allocations where LVIAs were required, and we sort of said then that the plan can't get into just being a validation checklist. It's not about that. It's about where you've identified a particular concern or a particular sensitivity. Then yes, those allocations should provide an LVIA because of precisely that reason. I don't think it's justified to just have a blanket all development proposals, presumably of 10 or more dwellings, should provide an LVIA. It's very much falling into a validation requirement. Just because something's outside of a settlement area, you know, a scheme of 15, 20 houses, you know, on a sort of disused or vacant parcel of land outside of Hemel Hempstead, for example, are you really going to be requiring an LVIA? And if so, why? What's the context? What's the harm? What's the thing that you're trying to get that development proposal to avoid or demonstrate? And I think sort of this blanket approach, I probably do sort of share the views of participants that it probably does just go a bit too far, and it's straight into validation requirements rather than actually sort of policy requirements.
Thank you, sir. We'll take those points away. I appreciate it. I think this, from our perspective, this probably does go a little bit to the local context again, and trying to balance the local context and local circumstances, and particularly some of our, you know, strategic objectives of the plan with regards to landscape and the importance of design, and trying to do that. We will take that away. I think it's a reasonable discussion. We're aware of the views on this. We need to kind of balance that with probably our own requests. I think on the point of the validation checklist, if I may, there's a slight nervousness of maybe in this instance we can understand the rationale in regard to the guidance. That's appropriate. There's been a lot of reference to the need to delete reference to specific studies and stuff. I just want to be clear right now, the council doesn't operate a validation checklist. That's not saying it's not something we want to consider tangibly. It's just in terms of priorities and workloads, it's something that has you know, was due to come next. It just makes me a little bit nervous that by removing reference to particular studies and in the absence of a validation check, I know it's more of a procedural point, you know, outside of plans. I'd just be nervousness with regards to, you know, the removal of specific studies reference from policies in terms of that clarity point in the absence of that checklist. But That's not, we are looking to respond positively to that point, and I will be taking that further with the wider planning service.
Ultimately, these policies are used to consider development proposals against. If you got into a situation where you were determining a plan application and there was a landscape consideration, you wouldn't refuse planning permission. Let's probably reword that. You could refuse planning permission, but the council presumably wouldn't refuse planning permission because a scheme didn't provide a document. The council would be refusing planning permission because of an impact, be it a harmful landscape impact. That's what it's about, is the consideration of landscape impacts and ensuring good design. Planning policy shouldn't be about tick box exercise. It goes back to the point I raised earlier, is that, okay, one side of A4, there's my LVIA. It says LVIA in it, I've complied with your policy. That's not what it's about. It's about all the things that Dr. Thompson said. It's about ensuring good design. It's about context. It's about character. They're the things that your planning policy should be looking to achieve, not sort of tick box exercises of, well, have you or have you not provided this document? And I think that's a concern that participants have as well, is that, sort of potentially onerous requirements for some, in a lot of cases, it will be relevant. Completely agree. But I think just having a sort of a blanket approach isn't justified.
We'll take that away. Thank you.
Yeah. Mr. Bristow?
Can I just ask one question? So I'm conscious you're reflecting on the sort of purpose of this as a whole, and I think that's entirely right, of this criteria. Settlement areas, though, those are defined, or settlement boundaries, they're defined on the policies map. Obviously, certain development within settlement areas may have an impact on the landscape. So I think that's just a sort of point of fact. But where in the plan do we go to, and this comes back to a point Mr. Birkinshaw made earlier, where in the plan do we go to see what the different treatment in broad terms is in settlement areas versus outside of settlement areas? Or is that sort of implicit policy?
I think that's more that general point. I would say initially, I would say the point one about the all development shall conserve, restore and enhance the prevailing character. And that's the all development approach. And there, when we look within our settlements, needless to say, we'd rather be more closely aligned with what the guidance is seeking in terms of those requirements. So again, this is about the local context. It's about once you leave those boundaries, and we are in many parts looking at, either standing within or within the setting of the national landscape, and it runs through the middle of our, cuts right through the middle of our borough, and there's land to the northwest and land to the southeast that forms part. It's an important consideration. It's a local context, and that's why we feel once you go outside of that, it was in our view, just a need to ensure there's a check, but notwithstanding the views made, I think I expressed, which will be taken into account.
Just to sort of help you out with this, one thing you could do, and again, I'm sort of thinking out loud. One thing you could do is change the emphasis of the policy slightly, where you've got your sort of the first part, which is the sort of all-encompassing, all development shall be good design, respect, character, etc. You could, just I'll put it out there, say something along the lines of all development shall demonstrate how it does A, B, C, X, Y, and Z. Then within the supporting text, you could say something along the lines of, yes, there's some sort of very sensitive areas of landscape, countryside, you've got the context of the OMB, etc., etc. And then ultimately, you sort of achieve the same outcome, because if, council, you get that plan application that comes in and it's got some, it's lacking in its justification, it's lacking in its evidence, then you can say, well, hang on a minute, it doesn't demonstrate how it does A, B, C, X, Y, and Z. And then you're moving away from the very tick box, have you provided an LVIA, yes or no, to actually sort of saying to applicants, show me how you demonstrate that you've done these things. And I think, anyway, it's just an idea. It might get you to the same place and give you the same sort of comfort and the same sort of protection, if you like, but without getting into this sort of backwards and forwards around, oh, I provided an LVIA. Actually, it's not about the provision of a document. It's about providing evidence to demonstrate how it's good design, reflects local character, etc. So I don't know, that might be a way of achieving the same thing with a more proportionate, method for everybody involved.
Thank you, sir. It's helpful.
Yeah, sorry. It's a really minor point. Obviously, we will wait on main modifications to understand what the proposed approach is and whether or not the council adopts that approach. But it was a point that Dr. Thompson made was unclear on whether or not it's measured in the context of national landscape or generally. Just for the note, as much as anything, I would just say, in my mind, it is clear that it is intended to be a general proposition because in E5.3 makes reference there to footnote 11 on page 75 that does explicitly refer to the national landscape. So this is a general proposition, and I would support the way a change in approach, a change in emphasis of policy, as has just been suggested or offered.
Thank you. I'm just seeking a little bit of clarification. I think Mr. Bristow went and made the point I'm going to make, in that I don't really understand. We don't really understand the LVIA with the sites have been picked as allocations and at a very early stage put in as constants. They are then, as if I understood the answer correctly, they are then part of the settlement boundary, and therefore the LVIAs will not be applied, despite the fact that there's evidence that from across the AON there is AONB, there is clear evidence that it will have a visual impact. And so at this point, if they're saying that this is a part of the settlement because they've agreed it, then none of this gets assessed. If that was the answer, if I understood the answer correctly.
And I think in response to that, that's why I've suggested maybe this change is needed. That sort of is an all-encompassing, development proposals shall demonstrate how they, and then you sort of removing this ambiguity around, are we in a settlement? Are we not? Are we 2 stories, 3 stories, 2.5 stories? What are we? Just no, your development proposal, you need to demonstrate how you meet this policy. Ms. Mitchell looks like you're about to say something.
Only if I was asked specifically. I think we've got, just to point out, we do have the landscape considerations, so site-specific landscape considerations within all the policies where that was relevant as well. It's where, through consultation comments, it's been raised that, or through the evidence, it's been raised that there may be a need to have a landscape and visual impact assessment alongside that as well. That's when it's been included as part of the site policies, but the landscape considerations are still relevant for the Berkhamsted sites, and they're still included. It's just not the explicit requirement to do their own full LVIA, just based on, I'm reading the 2023 response from Natural England saying the retention of the allocation is largely acceptable, and then they refer to priority habitats.
Definitely allocations, where you've identified something, potential impact, there's necessary LVIA that needs to inform design, layout, etc. That's justified. Generic policy, I think, have a look at the wording. You can probably make it clearer, less specific around this this sort of LVIA for everything. But nevertheless, do look at the supporting text because you can probably actually word in a lot of the things you just told us in the hearings about. In some cases, yes, it will be entirely necessary for an LVIA, and talk about the the context, of the area, etc. Any other comments then on any one? Anything, Council, Mr. Bristow? Okay, what we'll do then is time's racing on, we'll take a break now, and then, so I think that actually comes to the end of issue 1, doesn't it? It does, yeah. So that gets to the end of issue 1. Issue 2 is looking at sort of ecology really and biodiversity. So we'll take a break, and we'll come back at 5 past, is that right? Assume at 5 past, thank you. Okay, thank you everyone. We'll resume and continue. We've moved on to issue 2, and these are sort of the remainder of the NE policies effectively. There's quite a few to get through, but I think, again, what we'll do is just sort of take it at quite a high level and look at some of these sort of in particular rather than necessarily following all the MIQs. So, policies NE2 and NE3. Again, if I can just sort of start with the council and just ask you to sort of introduce these policies, and again, particularly if there's any suggested modifications or things that you think need to change from the submitted plan, please.
Yes, so policy NE2 is protecting biodiversity and geodiversity. This sets the plan's approach to biodiversity and geodiversity and how it will protect, maintain and enhance sites and habitats. There are a number of suggested modifications that have been proposed to this policy. The first is within NE21, where we acknowledge that there may be sites that are important for nature conservation that we're currently not aware of and may come to light through site assessment work, and therefore it's appropriate to modify NE2 to add the word identify in, so it becomes proposals will be expected to identify, protect and maintain, and where possible enhance sites that are important for nature conservation, habitats, ecological networks and geological and geomorphological interest. The second change is to policy NE2 criterion 2B. This arose from a representation from Education First, who pointed to Natural England and the Forestry Commission's advice regarding buffer zones for ancient woodland, ancient trees and veteran trees. As a result, we're suggesting a change that the minimum buffer of 10 metre of complementary habitat is provided to all retained priority habitats, except for ancient woodland, adding in the word ancient, where a 15 metre buffer will be required. We note that there's a requirement within the framework, paragraph 85A, for plans to identify, map and safeguard components of local wildlife-rich habitats and wider ecological networks. And we felt that it wasn't sufficiently clear on where information on those networks within the borough may be found. To clarify this, we propose modification to paragraph 6.7, which explains that biodiversity and geodiversity assets are divided into statutory and non-statutory sites, whereby we would add a footnote to say that the Hertfordshire Environmental Records Centre manage biodiversity records within Dacorum Borough, and the Hertfordshire Local Nature Recovery Strategy has mapped key areas for nature in Hertfordshire, and the Council's policies map will reflect the most up-to-date information that is publicly available.
Any comments on NE2, either what we've heard or anybody else suggesting any modifications that are necessary? Yeah, Mr. Turnbull.
Thank you, sirs. It's only a minor point to do with NE2 part 1, and I thought the MPPF talked about protecting and enhancing biodiversity and geodiversity. And on that basis, we're not happy with the first sentence where it goes on where possible enhance. I think it should actually just say and enhance, so lose the where possible.
And just quickly relooked at that. So I think you're referring to paragraph 180A of the MPPF, that planning policies and decisions should contribute to and enhance the natural and local environment by protecting and enhancing valued landscapes, sites of biological, protecting and enhancing. That's what you're referring to. And I think, and this crops up, sorry, the reason I've jumped in is this phrasing crops up in terms of heritage policies later. My feeling is that it's in there already, but feel free to tell me I'm wrong by your account. Proposals will be expected to protect, maintain, and where possible, enhance. So I think that gets the point across, does it not? That there may be instances where enhancement simply isn't possible for whatever reason, but there may be a possibility of enhancement in other situations. So to my mind, maybe that gets it across, but what would you say to that?
Well, my starting point is what the policy says in the NPPF, so it is enhance. It's not sort of saying, well, if you can enhance it, oh well and good, but if you can't, we'll accept, just protect and maintain. That type of decision is at the development management stage, at the application stage. If you're failing to meet a policy, you balance that with the other issues that are relevant to that particular proposal. You don't take it away at the starting position, you deal with it later.
Sure, and I think, sorry, what I'm getting at is it's possibly relevant proposals. So relevant proposals should be expected to protect and enhance. I think there is a necessary qualifier, as in not all proposals may be sort of caught by that by that ambit. And I think that's what the council has sought where possible, but that's a useful clarification that potentially its relevant proposals will be expected to protect and enhance. Because you may, of course, get change of use which has no effect whatsoever in terms of the national.
Yes, I accept.
Yeah.
It might be the word proposals then that you are looking at, because that then leads on to which proposals and the expectations. So you see your example of change of use is a good example in that you're probably not going to have that opportunity.
Dr. Thompson, did you want to come in at that point?
I mean, it's really to support what Mr. Turnbull has said, and also to question the relevant proposals point, because the National Planning Policy Framework says planning policies and decisions should contribute to and enhance, and then that in paragraph 187, and then that A, protecting and enhancing valued landscapes, is clearly meant to be something that is applied. I mean, there is that kind of logical argument that it can only be relevant proposals and it can only be where it is possible to do, but that's not what the NPPF says. So it's inappropriate for the local plan to weaken the NPPF policy.
Mr. Leyden. Thank you, sirs. Recognise the points and consistency with the NPPF. I do think we do have to balance this requirement, and I think it goes back to the previous one when we look at that policy on landscape and talking about all developments. It doesn't necessarily mean every single development is going to have an impact on a landscape. But in this one, considering every single proposal, and we've gone through that point. So when it talks about all development, I think is it no different in this case, relative to the fact that we are in the first point again putting that broad capture all into this. On the point of the where possible, again, this is perhaps something in terms of effectiveness. I would tend to agree with you, sir, that is that going to, is the intention of national policy there, is that's an overarching requirement of that, and I appreciate that, but we defer to your view, I think, on whether we feel it's necessary. I think we do have to be mindful that there's two distinctions in protecting and enhancing, which we understand. It's on the recognition, obviously the environment is an important consideration. But when it comes to the effectiveness of determining applications, which is what we're trying to look at the wording for today, is it expected that direct translation of paragraph 180A is expected to be absolutely verbatim applied to every single development, or is there opportunities that should be allowed for that where possible point, reflecting that we are trying to find the right balance here, but without creating more issues at the application stage.
I think it may be one instance where simply, I mean, this is me thinking out loud, criterion 1 reflects strictly what policy says, which, as Dr. Thompson and Mr. Turnbull have rightly said, is protect and enhance. And then the council just applies a view on a case-by-case basis as to whether that's relevant to a particular scheme. I'm just trying to think if there's anything, is it unsound the way it would be phrased like that? No, but the council would inevitably, as Dr. Thompson, recognises, have to apply that proportionally to a case-by-case basis without necessarily weakening the policy. So probably sticking consistently with the wording of the MPPF there and applying that in a proportionate manner as you go through the development management process is just what you do anyway. Okay.
So can I just add something, just I hope it's helpful. We will go away and consider that in the light of the comments made. And we've also got to bear in mind the correct legal approach, and you will, and I'm sure Dr. Thompson will appreciate the point, case law relating to the test of protect and enhance as far as national landscapes are concerned. It doesn't follow, because of that formulation, that there can't be harm where there's a failure to enhance. So that we've got to bear that in mind, and I suspect that may lie behind some of the current wording, but we'll take that away. I just thought it was wise to flag that up.
That's a fair point, and as I say, it also crops up in case law related to heritage assets. And we have the same phrasing in some of the policies there, which I wasn't actually going to raise, but there is case law on heritage that a preserve or neutral effect meets the relevant requirement. So, whereas the policies that you have there are also protect and where possible enhance. So I think you're right. I think have a reflect in terms of consistency with the wording of paragraph 183, but obviously in decision taking you'd be bound by case law. So yeah. Okay.
Me too. Thompson.
It was just to pick up on something that Mr. Turnbull said, and which I think will help with the council's point, that the comfort here in the flexibility is in section 38.6, that you follow the development plan policy unless material considerations indicate otherwise. If the development plan policy is setting a slightly lower bar, then the material consideration, the balance is already tilted in favour of a development that causes harm. So the policy should be setting a high bar, but you can overcome that with an other material considerations argument that might outweigh the protect and enhance policy.
I think that's fair. 38.6 is a fair observation, and I think the council is taking away just to make sure the wording there is aligned with the framework, consistent with the framework, flat VAT, if you like. My only last question on NE2, and I'm sorry to bring us back to TRO1, but I will do it very briefly. And it's about the interaction of NE2 with SANG, suitable alternative natural green space. And we know at TRO1 there is, and Ms. Mitchell pointed it out in the council statement, there is an area of priority habitat. We have criterion 2B of policy NE2, which says effectively have a buffer, and we've heard from Ms. Covington in terms of what that buffer might be, depending on whether it's ancient woodland or otherwise. But presumably that doesn't apply to SANGs, does it? Because we have a SANG at TRO1 proposed that is on a priority habitat, as I understand it.
That's correct, sir, yes. In essence, I think the nature of what the saying will seek to do is the saying will allow for enhanced, it should seek to, in any case, deliver an enhanced experience both to the existing established wildlife site, as part of that overall. So it doesn't, the buffers don't apply in that instance.
But the buffer would still apply to the protected, to the wildlife site. It would still be a wildlife site because the priority the habitat would remain. So, and I believe the master planning exercise does take that into account on TR01 anyway.
Is that reflected somewhere? I'm just thinking practically, if someone's going forward with a SANG and they're looking here and they're looking, right, there's got to be a buffer, priority habitats, we've got to provide a buffer, so we can't provide a SANG there because we have to provide a buffer to priority habitats. Now, setting aside whether SANGs are development or not, that we could spend hours on that. Is there somewhere in terms of the plan that's set out that this does not apply, this minimum buffer does not apply to provision of SANGs?
Our understanding is you can have a priority habitat within a SAG. And so in any case, I think where that applies, it's obviously going to be anything that might be detrimental to the habitat. So in terms of the buffer, I guess it's what it's relating to, is that buffer is probably ensuring that development or built form and components like that need to be mindful of, that relationship and that buffer. But when it comes to SANG and the provision of natural green space, having that, and it's absolutely appropriate. And there are examples elsewhere where that habitat, can thrive within the context of a
Yeah, of course. And I'm not questioning any advice you've had in terms of SANGs from natural England. I'm not questioning the principle necessarily. I'm just questioning the articulation of it in the policy. So if someone is coming forward with a SANG, they read that, do they think, oh well, then it can't be here? I don't know. I'll have to think about that in my mind because we're coming on to SANG policies. But it was just a point of clarity on that. And I think the answer is it's not set out in the plan. But it doesn't matter. So.
I think on TR01 as well, so we asked for that note, didn't we? If you just obviously liaise with Natural England just in terms of the SANG strategy, so that would pick up any potential issues with that approach there.
We just as an update on that, we do have the material. We're just waiting on confirmation, I think, from the county council that that because it's direct correspondence between the county council and Natural England, which we would have seen on the suitability, but there is comfort coming in relation to that.
Any three then net gain? Just again to the council, really sort of any and I'll sort of open it up for discussion from representatives. But anything you think in that policy needs changing from the submitted plan?
Yes, as set out in our hearing statement, we consider a modification is necessary. When the policy was written, the Hertfordshire Nature Recovery Strategy wasn't in place, and therefore it was appropriate at that time to set how the strategic significance score will be determined within the statutory matrix. The Hertfordshire Nature Recovery Strategy has now been published, and we're suggesting a change to policy NE32 to make it clear that that is the document to be used to assign strategic significance within the metric and remove any confusion to plan users.
Any comments on this policy? Ms Thompson? No? Anybody else? No.
Sorry. I just have one. I mean, I think it reads very, very well, subject to that clarification on the local nature recovery plan. Criterion 3, I didn't quite understand criterion 3. All development proposals where habitats fall below the de minimis threshold for biodiversity net gain. So presumably where you're not caught by the mandatory statutory BNG, should seek to incorporate biodiversity enhancements into design. So even where you're below the requirement for BNG, you should still deliver biodiversity enhancements.
Yes, we felt that there are measures for biodiversity which aren't captured within the net gain metric. For example, swift boxes and the like, and it was really to capture those opportunities. The de minimis threshold was selected because it's based on the habitat area, and therefore in areas of regeneration where you have a lot of built form, potentially you would lose opportunities of designing those types of elements into the built environment.
I think that's a very fair point, but are we talking about whether habitats fall below the de minimis threshold, or are we talking about where schemes fall beneath the threshold for biodiversity net gain? So presumably, I thought it was the latter, i.e. stuff that doesn't have mandatory biodiversity net gain should nevertheless seek to incorporate biodiversity enhancements, which I can't see a problem with. But what's where the habitats fall below the de minimis threshold? Is that in the biodiversity metric where a habitat falls below the de minimis threshold?
Yes, there are criteria in terms of the area of habitat that would fall under the point where biodiversity net gain is trigger. When we wrote the policy, we felt that that was an appropriate approach given the amount of built development and regeneration we have in the opportunity areas. We can review the policy and see whether it should apply more broadly to applications that are not applicable to the mandatory biodiversity net gain.
Yeah. Is it that you're saying schemes which are not subject to mandatory biodiversity net gain should nevertheless seek to incorporate biodiversity enhancements as appropriate? It sounds to be that's the, which makes sense because the MPPF talks broadly about seeking enhancements to biodiversity. It seems like that's what you're getting at. I think we could support that. It was just about the complexity of the phrasing in terms of effectiveness. Would someone know if my habitat falls below the de minimis threshold or if it's biodiversity net gain that it doesn't apply? So I think it's probably something like that you're getting towards. Is that correct?
We had focused on the de minimis threshold, which is impacts less than 25 metres squared of on-site habitat, but there are other criteria by which types of development are exempt.
You could just add some supporting text just to make that clear. I think would be the way forward.
Thank you.
On policy NE4, again, we've talked a lot about obviously the principles of SANG, and we've talked a lot about the Chilterns Beach Roads SAC. We've talked about the habitat regulations assessments all the way back in week 1. In terms of the sort of effectiveness of this policy then, again, just by way of introduction to ask the council to just run through any sort of areas of agreement or disagreement potentially with Natural England, and again, any changes that you feel are necessary.
Yes, we have reviewed the wording within policy NE42, which relates to how proposals within the SAC and its 500-metre exclusion zone will only be supported where an appropriate assessment concludes that there are no functional links within the habitat site and there is no potential for harm to arise. Oh, sorry, that was, yes, that's correct, NE42. And we felt that there is potential conflict with that criteria and the operation of NE6 gateway principles, specifically because the gateway principles require that mitigation to be located adjacent to and within the radius of 500 metres of the boundary of the SAC. Therefore, to clarify that point, we're suggesting that NE42 is changed to Proposals within the Chiltern Beach and SAC and its 500-metre exclusion zone will be supported where an appropriate assessment concludes that there are no functional links with the habitat sites, or if functional links do exist, that there is no potential for harm to arise. Moving on to other changes, you recall in the discussions regarding the Tring site, there was the discussion on James Farm and how the County Council is now seeking to provide a SANG solution on site at Cow Lane Farm Meadows, and that has been agreed through the Statement of Common Ground. And in order to, again, ensure that there's no conflict with the list of SANG sites that the plan allocates in NE 45, we're suggesting a number of changes where TR01 Dunsley Farm is added to the list in 5 of the local plan allocating land for SANG mitigation as part of wider site allocations. So TR01 Dunsley Farm is added into that list, and then removing James Farm from point I of the list below, which identifies other locations for SANG. And then one final minor point, in their submission at Regulation 19 consultation, the National Trust asked that the name of Hill Farm in 5A be changed to Landlet's Hill Farm to remove any confusion about Hill Farm itself, which will continue to operate another farm with that name within their estate. And one final change in paragraph 6.16, again, the National Trust asked if the progress of the spatial plan to guide the future management of the Ashridge estate be updated. So rather than saying the National Trust is also preparing, for that to read, the National Trust has also completed.
Okay, thank you. A couple of questions from me first. Point 1, all relevant development proposals will be expected to assist in the conservation and enhancement of the biodiversity, character, appearance and landscape setting of the Chilterns Beechwoods SAC. What's the justification for that? And particularly I'm here talking about character, appearance and landscape setting.
I think that's something that we could probably take away and look at relative to the wider policies of the plan. I think message is coming through on that it possibly sits better within the other landscape policies that was discussed.
Yeah, I think there's a potential risk there that you're sort of introducing some. This policy is all about, obviously, integrity of that site, recreational impact, etc. So I think sort of starting to refer to those other things, that there's a sort of potential confusion and conflict there. The second question I had was point 3. So this is essentially where you are requiring the provision of mitigation, and the mitigation is presumably agreed with Natural England, that it's SAM strategy and the SANGs as well, so suitable alternative natural green spaces. The phrase elsewhere, or qualifying development, then sort of takes you on a little bit of a sort of working out. So you go down to footnote 17, and then it's a qualifying development is any proposal that is screened in at stage 1 of the HRA and is subject to stage 2 an appropriate assessment. And then that sort of takes you back even further into the supporting text, where you've then got to try and work out whether you're screened in or it's all a little bit convoluted and a little bit messy, if I'm being perfectly honest. I would just go on the basis of, where do you require, so if the development proposal comes forward, is it clear to users of the plan whether or not they need to provide mitigation? Presumably, it's within the zone of influence, and is that shown on the policies map?
The zone of influence, for clarity, is the extent of the zone of influence encompasses the whole of the borough. So it actually extends beyond our borough into neighbouring authorities. So we just take it as being right now, currently, it is the whole extent of the Dacorum outside of that initial 500 metres. That may change through updated evidence. So if evidence demonstrates that needs to be reduced, then we need to ensure the policy is keeping up to date with that, because what we're trying to do here is naturally apply a legal process, but ensure that we have a policy in place that reflects that process in a manner that we can better inform our decisions and reasons for permission as well as those for refusal.
So essentially any windfall sites coming forward would be into the sort of SAM and SANG strategy territory.
That's correct. And yeah. A second point, just on that qualifying, and this is not it's a complication, regarding the qualifying development, rule of thumb, finger in the air, all net new residential development would be within that. But there may be instances, because it's recreational pressure, it will go beyond that and maybe a case by case. So a C2 development that is generally includes swimming pools and car parks and gyms might be screened in, but another one that is delivering end of life care may be screened out. Cafes or hotels in particular locations, ones that encourage. So it's a very, it's a consequence of the complexities that we've been through in recent years, that we have tried to capture as all qualifying development, but there are many, many instances where it would be A, case by case, B, the location relative to the SAC. So to your point on that, I think we wish we could be clear on that too. We will revisit that in light of advice and see what we could do. That's whether within supporting text that may aid that.
Does the supporting text make it clear then that if effectively everything would be within the zone of influence?
I don't think it's specifically stated, and I think that is on the basis, as I say, that if further evidence was to demonstrate it was to be halved, then that supporting text may be out of date. But I think there is no reason why we couldn't make that more clear and say that, at the time of adoption, it is this.
I think you're right. I think criterion 3 does work then. It was that elsewhere, and okay, where do I go? I think if you added some supporting text in to say essentially, at the time of the plan's preparation, zoning was extended across Dacorum Borough, and therefore all qualifying developments will be required to mitigate recreational impact. That then neatly ties in with criterion 3, so you probably then don't need to start changing criterion 3, because it's clear that, okay, I'm a developer, this is obviously quite a technical thing, do I know what I need to do? I read the plan, I go to supporting text, right, okay, I know exactly what I need to do, I'm into mitigation strategies. So it probably comes somewhere in around 614 or 615, something like that, an additional paragraph for effectiveness, I think. Any comments on any 4? Yeah, Mr. Clements.
Yes, sir. Thank you. Our issue is not with the policy per se. It's with the implementation of the policy, and particularly with your question 2 as to the meaning for the council of all SANGs being correctly identified and available. We have referred to this in our submissions on this question regarding the availability of SANG. And it goes to criterion 1, sorry, jumping forward to policy NE5, criterion 1F, as to when SANGs will be required to be in place. And I raise the point simply because we are at the moment dealing with this from an implementation perspective.
Sorry to interrupt. So is that an NE5 point?
It's an NE5 point, but it goes over into your question on NE4 as to the availability of the SANGs and what that means from the council's understanding or intention within the policy. Thank you, sir. Yes, it goes to that because I don't want to sort of stray away from the policy and into an implementation point of view, but I think it is relevant because we are coming up against circumstances now where there is, through an implementation perspective, there is a requirement for SANG to be operational and available in that sense, and in place and operational at the time that applications are determined. Now, my understanding of the tests, the HRA tests relating to certainty, is to whether the mitigation strategy provides the necessary certainty under the habitat regs. Our understanding is that is the case if the mitigation strategy is sufficiently robust to set aside any concerns about impact on the integrity of the SAC, and I believe that is the Council's position and indeed Natural England's position, that the mitigation strategy itself is effective. The point of certainty then crosses over into whether that needs to be in place at the point an application is determined, as to there has to be certainty of provision of SANG, i.e. it's in place and operational, at the point an application is determined. That's not what policy NE5 criterion 1F appears to be saying. The requirement being that the operational SANG is in place at the point of the occupation of the qualifying developments to which it relates. That is our position, and that comes then to the use of conditions and the use of Grampian conditions if there is a prospect that the mitigation will be available and in place. And the extended point to that, sirs, is that the Council's housing trajectory includes windfall provision from 28-29 onwards across the whole of the borough. As we've just touched upon, all windfall developments will have to meet the mitigation requirements, and therefore at the moment, I mean, I'm certainly aware that there are a number of those SANGs that are not operational and are subject to the planning process, as the Council's statement refers. We would contend that there isn't a need for them all to be in place and operational at this time, or at the time necessarily that applications are determined, but there needs to be a prospect that they will be in place to be effective for a condition to be imposed on planning consents that prevents occupations prior to an operational SANG being in place. The point is one of clarity, sir. So the circumstances that we are encountering at the moment, where there seems to be a confusion between development management and indeed what Natural England is saying, and the intention of the policy, which I think is you know, albeit across 2 policies, 3 policies, correctly expressed. Thank you, sir.
Thank you, sirs. And it is correct. This is an important point. So I think it's important for your knowledge and benefit just to take you through, just for a few minutes, just some of our evidence on this, just to explain where we've got to on that. So if I may, if we could take you to the Habitats Regulations Assessment, CD 06.1. And on that, if I could refer you to PDF page 134, you will see a map. It's an appendix which sets out our SANG strategy, starting on PDF page 133. On PDF on 134, you will see a map that talks and presents an image of SANG catchment areas. Good if you can see that. On that map, you'll see a number of sites, red line boundaries, and their catchments. And in that, you'll see that those sites closely relate to the policy as submitted, including number 3 at James Farm, which we're seeking to now, you know, relocate to Cow Lane Farm. But on this point, obviously we are seeking to ensure a strategy that seeks to deliver homes and a strategy that supports growth and accelerates housing delivery. But you will see, obviously, with our spatial strategy, when you look at Hemel, if you can see Hemel on that map, you can barely see it because we have solutions for SANG at Hemel, live solutions that are enabling growth, and there is other solutions coming forward through the planning process. But these are the ones intended and necessary to enable that. So you will see that in terms of housing supply, and looking at this one, which relates to major windfall, how major windfall will be served. So there is a degree of comfort and confidence, as also as the competent authority, that there's sufficient mitigation there. And you'll see that a number of that extends, particularly number 2, which is a live SANG, you will see that the catchment of that does extend to include half of Berkhamsted. And that's an important consideration as part of our decision-making process and recommendations. I think where the point in clarity and effectiveness, which I think is a reasonable one, is relating to this number 1 site on that map, which is the land at Hill Farm, the gateway, which is the National Trust gateway site that is identified within policy and is identified on this map. Now, without going into too much detail, as you scroll through subsequent pages, you will see that that's not intended to serve any developments in the short term. And I think this is a point of clarity and effectiveness that I think we need to be extremely careful on when it comes to that. So we are aware of the National Trust, and we're working proactively with the National Trust to bring that forward. But the gateway is a complex matter. It's a new, as set out in Natural England, it's a new concept that kind of goes beyond SANG. It is something that needs to sit close to the SANG, but also needs to be dealt with very, very carefully and sensibly for it to meet what you do not want to do is be adding a lot more recreational pressure on the edge of the SAC without ensuring there's steps in place to reduce the pressure from within it. So there's no net increase. And that process is taking time. And owing to the fact there's other complexities to do with common land, to do with other elements. What our view is, notwithstanding the view of National Trust and others, is that is going to take time for that number 1 site to come forward. And I do agree, this plan needs to be more explicitly clear, in my view, and I believe that the view of the team also here is that we don't expect that to come forward until the middle of the plan period onwards. Now, by saying that, I'm saying more than 5 years' time. So I think then, if the plan can do that and be explicitly clear, because notwithstanding the aspirational ones, we don't want to be restricting the delivery of this SANG. I'm just saying I have not seen the evidence yet to say it is ready and ready to go. And nothing is implemented. There is no planning application for that SANG. It is within the Chilterns National Landscape. We have to deal with that sensitively too. There's a lot of work to be done on that side. So when it comes to the reasonable certainty, and going back to maybe earlier discussions about why we consulted on a focused consultation that reduced growth, we are basically telling site promoters, we do not have all the solutions, and we are looking at solutions. Please come and give us solutions. And you can see that a number of those sites are now including SANG proposals and are within the plan. But for those without their own solutions, they have to rely in these locations on something that the council has no control over. What we can do is allocate, but we're not landowners as we would do for some of our land in Hemel Hempstead. So when it comes to that, I think this particular point on Grampians is perhaps not something for today, but that's part of considering the legal process, but it's about the reasonable certainty. But when it comes to the points on when SANGs are going to be likely or estimated to come forward, I think the plan could do more on that to give prospective applicants and speculative developments and those applicants a chance to understand where their site sits in that programme of SANG delivery. Now you'll see that that particular one only kind of really addresses a small area of the western half of Berkhamsted. And as you can see that there's other SANGs that will come forward. But my point here is that when it comes to the Grampians, we have to think about the extent of a planning permission and the likely extent and the contribution that that site and that permission will give. So in our view, if we are looking at a position where we don't think there's enough evidence that mitigation can be secured within the lifetime of that permission, then is there any benefit in a Grampian condition? That's a slightly separate point. I think within the plan, I think this plan and perhaps where these signs are either now live or due to come online shortly, you know, we can probably do more within the plan within the supporting text to spell that out. But we do not want to put those estimated timescales for delivery perhaps against them. But we do need to provide that extra clarity. I hope that's helpful.
So just in terms of the point that's been raised then, which is NE5 criterion 1F, signs to be delivered prior to occupation of qualifying developments. Do you think that that is sound as submitted then?
Absolutely, yes. On the advice of Natural England, SANG needs to be in place and effective and operational at the time that homes are being occupied. But to secure that, if people are expected to contribute, there needs to be a lead-in time from when contributions are sought to where that is implemented and effective on the ground. And for that, our normal process, as set out in the mitigation strategies, we secure that prior to commencement of development. We would normally expect that. Now, the use of granting conditions may be acceptable, as the council has used, where there is confidence that it will be online within 2 or 3 months. But when we're looking at a period of 5 or 6 years and the reliance on a solution for that, that is, I think, the bone of the discussion today. So when it comes to the policy, I believe it's sound, but it's how we apply that policy at the application stage. It has to have regard to not just the signs that we have in our plan, but any other signs that might come forward also.
So, Ms. Clements, what would you expect us to recommend to modify criterion F then?
I think the point, if I may say, just going to Mr. Layden's point, the 2 or 3 months point is not reflected in planning guidance. It's within the lifetime of the permission, and obviously that is at the discretion of the decision maker. So one could apply a standard 5-year life to the permission, but that of course could extend depending on the period taken to determine reserve matters for an outline proposal. So I think it's within the gift of the council as the decision maker to determine the length of a planning permission, taking into account reasonable factors that would impact on that. So I'll come to your question in a moment. The point that is of interest to us particularly is because, I mean, Mr. Layden suggests that the Hill Farm Gateway SAN won't come online until the middle of the plan period. I think it ought to be saying that appropriate conditions would be used to ensure that development or the occupation of qualifying development doesn't come forward until SANG provision is in place to serve that development. It could refer to the use of appropriate conditions to guarantee the outcome. That could be something that is referred to in supporting text. It just...
But then that's inferring that planning permission has been granted. If you're referring to, we'll use conditions, and I think that was the point that I think Mr. Layden was probably getting at, is that, you know, we've jumped straight into a world of planning permission has been granted, we'll use conditions, it's fine. I think what the council is saying is actually, no, we want a bit more certainty around that, and hence why we've got this policy in place.
But we're not contending with the requirement for the SANG to be in place when the occupations take place, sir. No, that's reasonable, but it's making clear that the use of planning conditions could be an appropriate means by which to achieve that on the grant of a planning permission. I raise it, sir, because it is a point that we are encountering at the moment.
Well, yes, this is interesting because I'm completely with the council on this matter. I think the policy is sound. Mr. Clements very eloquently set out why he thought it should change, but he's basically talking about one particular site And I don't see how a policy of this nature and this importance should be changed because at the moment, one particular site in the borough is having a problem in proving that they can have a SANG up and operational when a planning consent is granted. It seems to me a completely reasonable proposal. And I think there are too many cases where conditions are applied to deliver something down the line, whatever it may be, and those conditions are not complied with, and very often planning authorities have great difficulty in enforcing them. So therefore, I think the policy as published is sound and there is no need to change it.
If I may, what I can't get quite my head round, and there's obviously something going on in the background, is given the legal principles that govern where you can and cannot use gramping conditions, why the policy needs to say this? I'm not quite getting the argument as to why a policy needs to clarify what can be done under various legal provisions anyway, because that way potentially leads to a number of relevant legal provisions. I can't quite get what the point is, if I'm honest.
If I may, sir, then. It may be that the policy itself doesn't require revision, but the supporting text to make it clear. Sorry, gentleman on my right, who raised the point about this one particular site. Obviously, yes, the site that we are interested in, but it doesn't necessarily simply relate to that site, because the council's housing trajectory, which it has supplied to you, includes windfalls, as I've mentioned, coming forward across the whole of the borough. And the SANG in question, the Hill Farm Gateway SANG, as Mr. Layden has said, is the only SANG that actually covers the whole of the borough. So there is a reliance within the housing trajectory on windfall sites coming forward across the whole of the borough, which, looking at the evidence, it would suggest that the Hill Farm Gateway SANG is the only one that could accommodate such in every situation.
And that's not so much a point for here, is it? That's a point for windfalls in terms of sorry, I'm just thinking if the argument is about whether a gramping condition can apply, well, obviously look at the PPG. You'd look at case law that said you can't grant a gramping condition if there's no prospect that it will be fulfilled. I can't see why that needs to be articulated in the policy in order for it to be sound. But I can understand now your perspective in terms of windfall provision we're coming on to, and I think that's probably where we'll need to address it.
Yeah, the only point that I would take with any 5.1f, whether it's a policy point or whether it's a supporting text point or whether it's an allocation point, is presumably on some of your very large strategic sites, and again, correct me if I'm wrong, but presumably some of the SANG would be provided. Well, those sites come forward in phases, won't they? So there's probably some consideration around when and how the specific SANGs come forward. I'm talking probably on some of the very larger sites, thousands of dwellings. Would that still apply, or would there be sort of bespoke phasing strategies there to sort of demonstrate, well, this parcel is going to come forward for whatever uses? I don't know. Is there enough within the plan for some of those larger sites to still come forwards where they've got sort of bespoke phasing arrangements?
So I think just to be clear on the matter of sites and the largest sites, there is an ability for SANG to be phased alongside development, yes. I think on the specific point of 1F, and again, this is an initial point, we're trying to translate what we understand following a legal process of habitats regs. and what that means in terms of applications. And the advice from Natural England is very clear, always has been, that SANG and the mitigation needs to be in effect before any homes are built, and that it needs to be available for those on the day, because it deals with principally and mainly with pressures from new growth, not existing growth, just new growth. And that by allocating these homes, that there's that point. And it's the reasonable certainty point, which is, that, again, one of the legal tests on this, the reasonable certainty that mitigation will be available and secured and be available at the time. And that's what informs the decision-making process. So, again, the Council maintains a particular, as set out, we see that policy is sound. Our approach has been in place since 2020, late 2022, hasn't been subject to any rigorous, successful, or otherwise legal challenge. And again, you know, it's what we have learned over those last 4 or 5 years has been reflected within the policy today.
Yeah, I think the point's more relevant to your delivery and when sites coming forward, rather than a sort of 1F point. I did want to talk about NE6 though, gateway principles. So just talk us through. Obviously, you've got your mitigation strategy, you've got your HRA, you've identified your SANGs, and there's some changes there, especially around the James Farm one, etc., etc. You then have a separate policy around gateway principles. Just talk us through, again, what they are. And if I'm a developer, I've got a windfall site, I'm coming forward, I know now what I need to do under NE4. What do I need to do under NE6 then?
So starting with strategic policy NE4, criteria 3.3b states that qualifying development will be required to mitigate for the recreational impact pathway on the Chiltern Beach with SAC in accordance with the mitigation strategy. This will achieve by making financial contributions towards strategic access management monitoring strategy or any subsequent scheme which replaces this, and also providing or contributing towards the provision of an agreed suitable alternative natural green space or gateway where the development is located within the related catchment area. So a developer would be able to mitigate by either making contributions towards SANG or a gateway.
Excuse me for being really blunt here. Is a gateway effectively another form of SANG or another form of mitigation?
It's similar to SANG, but it's different in that it's located close to the existing visitor facilities at Ashridge Estate, so near Monument Drive. And it also has both the minimum essentials that a SANG has to provide and other visitor facilities which aim to replicate the existing visitor experience at Monument Drive. I think that the key difference between gateways is that not only would they resolve mitigation from new development, but that they also seek to move existing visitors to the Ashridge Visitor Centre to the gateway, and thereby a part of a wider mitigation strategy of how we are dealing with recreational impacts in that core visitor hub, which suffers from that pressure.
I think
So you haven't got your microphone on, so we didn't
Sorry.
catch every word.
Sorry, and really in response to my question, you've actually proposed some additional text at 6.22. So is that really to, again, just provide additional clarity as to what these sites and principles are?
And the additional text in paragraph 6.22 is explaining the phasing point. We would expect the gateways to start with a core offer, which would be more similar to a SANG, and over time extend to become a wider gateway offer. I suppose I see it as a sort of a transition in that the existing facilities at Monument Drive would reduce as the replacement gateway expands and becomes, has a wider offer.
No, you go first. And sorry if, yeah, my question is really, when I was reading this, gateway principles and gateway proposals. So it's gateway principles, we've talked about gateway proposals, but then if you look in the supporting text and what we've heard, this is a very specific single thing, as far as I can understand it, that has emerged from the National Trust. They're preparing their proposals to effectively meet the requirements of a SANG, because we're told under policy NE6 criterion 3 that gateway sites must meet the SANG principles. So my challenge, and you may say it's a constructive challenge, or you may say it's an irritating challenge, is why is this policy needed? Because I really struggled to sort of understand it from the outside in. If the National Trust could anyway say that what they're proposing for the Ashridge estate qualifies, as it would have to under NE6, as a SANG. So that was my confusion with it. Or is it an invitation for others to provide gateway areas in a similar fashion that would also distract people from going to ecologically sensitive sites? So that was my mental struggle that I've just laid bare in front of everyone. Do you want to respond to that? And we'll come to Mr. Thompson.
Yeah, just very briefly on that, and very, very short. Yes, you're right. It applies to probably very select few sites, first and foremost, and we have one identified within our plan. B, going back to the process of the habitats regulations assessment and having a plan that satisfies the requirements of a habitats regulations assessment. Take into account mitigation. Mitigation can be in the form of SANGs, but can also be in the form of policy when it comes to mitigating effects and effects necessary. So when considering about if we didn't have a policy on gateways and didn't have any kind of structure for what they should be expected to do to satisfy the HABS regs assessment, then there could be a risk that the plan might not overall meet the requirements of the HABS regs. So it's taken about, well, we're allocating a SANG at Hill Farm, it's within the 500 metre exclusion, it's on the edge of the SAC. How does the plan mitigate the effects of that? Well, it needs that policy, the structure of policy in detail to ensure that they have to follow that. It's understand the points on that. It is a consequence of that. It is probably worth noting just in conclusion on that having regard to the natural England response to the regulation 19, which is obviously naturally important on this, in regards to NE5 and NE6, their comments, if I can, is natural England is supportive of the policies covering SANG and gateway principles. Through proactive consultation, we're confident that both provide a good foundation for the mitigation of development as part of Chiltern Speech with SAC's mitigation strategy. It is also beneficial to see how each allocation that falls within the 12.6 kilometre zone of influence has a named allocation SANG and or reference to contributions included in their description within the plan. They do talk about some additional detail, but they don't think it's fun, minor changes. They don't feel it's, they have any issues. They agree with our approach in terms of this particular point. And I'll just leave that one there, if that's okay.
Yeah, just in terms of their reps, I probably would agree, I was just reading them back actually, I think I probably would agree with their summary around the gateway principles and the phasing. And again, that would be supporting text. And again, it just goes back to that, that sort of like your developer decision maker, member of the local community, picking up the plan. What are gateway principles? What's this all about? How do I understand it? I thought I knew what was going on with the SANGs. I've got my head around that. And then this sort of gateway principle comes in as well. And it's just making it clear and making it effective as to what this is. Obviously, yep, it's your plan and you've got a real good understanding of what this is all about. I think it just doesn't come out enough in the plan for sort of users of the plan as to what that is. And I probably agree with National England's, yes. Yeah, they say further clarity, don't they? Would be good, I think. Any comments on any 6? Yeah, Mr. Churchill.
Yeah, thank you, sir. I think in reality, and it's a position we've put in our representations, we understand and accept NE4, but both NE5 and NE6, and I would suggest it extends to both of those policies. We take the view that neither are particularly clear, as in would they, in reading them and seeking to interpret them, and I would suggest, so that the mental struggle, you're not alone in that. Is there a lack of potential for confusion in the interpretation of those policies? Will they help the decision maker in however many years' time that those decisions come to be made? I would suggest that they're not sufficiently clear. And equally, I would suggest that in the context of the very clear guidance from Natural England, that they aren't necessary. So we would question their presence overall. They're obviously very long, word-heavy, criteria-based policies that we would suggest if there is any benefit in retaining the text whatsoever, it would be more appropriate within either supporting text or an appendix to the local plan rather than set out in policy that would require to be interpreted by the decision maker.
Okay, that's the point that Council's already responded to. I want to move on. Any additional points, Mr. Thompson? I think the council know what they need to do in terms of NE6, and it does sort of chime maybe with what Mr. Churchill was saying, just about making it clear what this policy is all about and where it sits and how it's going to be used. Putting yourself in that sort of decision maker sort of shoes. Okay, what is it that we want from development proposals? Mr. Thompson.
Thank you. So yeah, it was just to provide an additional perspective in relation to NE6 that, and I agree on reflection it's not entirely clear, but I think part of the reason for separating these principles out for the gateway site is that it's a form of development within the national landscape that could be problematic. And it's obviously something that the Chilterns National Landscape Conservation Board supports. We wouldn't normally support the scale of development, the insertion into the landscape of a development proposal like this, except for the fact that it's resolving this visitor pressure issue on Monument Drive that is, obviously of concern in relation to the SAC. So there is a need for a proposal, a policy, a proposal in the local plan that justifies the insertion of that development into the landscape, in addition to the SANG requirements that apply to it as well. Does that make sense?
The way NE4 is written is you make a contribution towards the SAM strategy. You then provide or contribute towards provision of SANG or gateway. How do you know what you're contributing towards? Again, just put yourself in the sort of developer's position. So we're not providing our own SANG. We're contributing towards something. How do you know if we're contributing towards a SANG, and maybe some of the listed SANGs, or this gateway proposal?
that's a question to us. That information is available on our website. It does, and there's an important point here, I think. So you need to go onto the website, look at where the signs are available. There's a mixture. So there's publicly owned sign, which is the Dacorum's owned ones. We have 2 of those right now. Then we work closely with others, such as the Foxmore Trust for Westbrook Hay, which would be number 2 on that map as well. And that's there to enable larger scale developments within Hemel and that area. Naturally, the principles of NE5 and NE6 are there to inform proposals for sign. So when you think about that side, this is saying that there's criteria. If you want to deliver a sign, there's criteria to deliver them. And in terms of the practical, and that's for those who want to say, I want to bring homes, but I will need a sign, but there is no sign, so I must find a sign. What do I need to do? And that will shape and inform that. And they have been shaped by the mitigation strategy, which is CSN 01.1 in our evidence library. All the principles there are stemmed from that. And with regards to the practical implementation, we know that that has been a very useful tool, and those principles have been very key in shaping a number of sign solutions at the application stage. So in terms of the effectiveness, and the points being raised about, is it necessary? Well, what we don't have is a policy position to shape a reason to approve or refuse specific sign proposals or gateway proposals. And it's important we do have that. But if another sign was to be approved, then that naturally changes the context of the catchments and what could contribute towards that. And I think that's an important point, a bit like the zone of influence point. That will change over time. And if someone else was to bring forward a proposal, we're aware there's other proposals not on that map that are being forward. There's 2 more signs that have been approved to the northeast and northwest of Hemel that aren't on that map. There is Haresfoot Farm, which we're aware there's supporting other developments. So it's a fluid situation. It's on our website.
Yeah, I think what you need to do, as I say, is we've got the comments on Action England. We probably share some of the concerns around just about clarity and effectiveness. And I think actually the answer might be in NE4, because you're right, NE4 is you sort of go to, this is your mitigation. NE5 is then, okay, I'm proposing this sign, this is what I need to do. NE6 is, I'm proposing a gateway, this is what I need to do. I think maybe where ourselves and others have got a little bit lost is sort of jumping straight to NE5 and 6 and going, oh, what's a gateway? What's that mean? What you could do, because you refer to the gateway in NE4, in the supporting text, it's then a little bit silent, isn't it? It does refer to the National Trust, preparing a spatial plan, etc. But it's probably worth adding supporting text. I feel like I've spent all week telling you to take things out and asking you to put stuff in. Is adding supporting text into NE4 to make it clear and sort of introduce this concept of the gateway. So NE4 is your mitigation policy. And as your colleague, Ms. Coveringham said, Part B is contribute towards provision of an agreed sign or gateway. And then you fast forward to NE6, and that's where we go if you're proposing a gateway. Is that right?
Yeah, we'll take that away. 6.22 is the principles of gateway, but I think in light of what I said earlier, we're quite happy to review that with the aim to try and make it more clear to the end user.
It's difficult, isn't it? Because you're right, 6.22 might almost be sort of, it could almost sit within NE4 really. But I think have a look at the supporting text, and I think that then makes it clear. And again, I'm a developer, I know what I'm doing then. And really, as you said, NE6 is really a guiding principle for gateway proposals. Potentially, is it fair to say, probably quite limited in terms of how it would be used? Obviously, we talk about the National Trust and their proposals, but potentially it could be because of quite a niche policy in that regard. In probably the majority of the mitigation, you'd be looking at NE5 and SANGs and people providing SANG. Is that fair?
Thank you, sir. It's just probably a brief statement on that point. It would seem to me, and I think you probably dealt with most of the things I was going to say, but it appears to me in terms of the developer knowing what the developer is required to do, it seems to me that SANG is mitigating the effects of development that is planned via the local plan, the allocations and the windfalls. That the gateways seem to be serving an additional function, which is ameliorating effects on the SAC that already exist. The council's statement says as much at 2.4.8, where it's actually seeking to address established patterns of visitor behaviour in respect of the SAC. So gateways are trying to do two things, it would seem to me. They're trying to mitigate the impacts of development that is proposed through the plan, and they are also seeking to address existing visitor behaviours. So that it seems in terms of understanding the mitigation of a developer bringing forward a development proposal would be to make contributions to SAMS and SANG for the provision of, let's say, the more simple version of the SANG. The gateway principles are, in addition, seeking to address existing behaviours that occur irrespective of whether the plan is in place or not. That seems to be my take on this based on the discussion.
There's very little more to add on that. It's part of a more rounded, and it's something that Natural England have advised us to start to look at as a new concept. Within that, mitigation exists. Now, I think when it comes to the contributions and the numbers and how much per dwelling that we might get to when it comes to contributions, that's all to be ironed out in time to ensure that whatever people do contribute towards in terms of gateway is only to offset the recreational pressure from new development, not any betterment from existing. That is something that the National Trust would have to do for themselves. So that is part of a process of what has to come and about this in terms of reasonable prospect test, with this site not delivering in the short term.
I think the answer is pretty straightforward. You know, it's the SANG strategy is clearly set out. Just make it abundantly clear, either through changes to policy or probably the sporting text in any form, the difference between a SANG and a gateway. And really then that takes you forward to policy NE6, which, as I said, potentially might be a very sort of unused is probably the wrong word, but a very lightly used policy. Potentially NE5 is probably where most people are going to go. I think that's a fair assumption, is it?
Absolutely, sir. Just a caution about, I think the reason for gateway is also there is, yes, there's only one kind of solution and they're relatively limited, but I think we do need to check any SANGs that might actually stray quite close to the SAC and going back to that functional link point. If there is public right of way that connects the SANG to the SAC, then, you know, is it a SANG or is it a gateway? And that's those kind of sort of dynamics about how we would consider proposals. It may be there are, you know, other land that's not National Trust owned that, you know, may want to bring forward their own gateway proposals. At least we would have that policy there to consider that.
It's difficult because, you know, there's a lot in this local plan. There's a lot of detail, and you know, like I said, we've sort of spent a couple of weeks telling you less is more, but then there are some instances where further clarity is needed. I think there is a danger though, especially with going back to the granting condition point, there's a danger with local plans that you try and cover every possible eventuality, and in doing that, there then becomes a scheme that comes forward which doesn't fit within the sporting text or the policy, and all of a sudden it's like, well, we didn't think of this. So have a look at it. I think you know what's, I don't need to hear any more on this. I think you know what you need to do. Just, again, clarity, effectiveness, they're the changes that are needed, and really understanding what this strategy says. But I think in the fair to council, there's a lot of evidence behind it, going back to HRA and the representations, the engagement from Natural England, and they sort of hit the nail on the head, don't they? For clarity around the approach, expectation, etc. That's what you need to do. So we will move on. The policies I want to move on to sort of do take us in a slightly different direction. It's talked a lot about sort of landscape, character, sangs, etc. The remainder of this morning's topics take us really to sort of NE 7, 8, 9, 10, 11 and 12, which are slightly different. What I'm going to propose we do, I still think we can get through these before lunch because I've only really got a couple of questions on policy wording. I'm going to propose we take a quick 5-minute break, if that's okay with everyone. We'll take a quick comfort break. For those who have maybe sort of participated and don't have any further comments, obviously if you want to leave, you can do. If you want to stay, that's perfectly fine as well. But we'll take a quick 5-minute break and then we'll come back and run to sort of slightly different policies, starting with number 7. Thank you. Okay, thank you everyone. We'll resume and continue. So again, just as we have been doing, we're on to NE7 by my accounts. Again, just in terms of council, any sort of overall sort of summary of this policy, and again, any changes that you think necessary, having considered any of the representations.
Yes, NE7 relates to protecting and enhancing the river character and water environment and related biodiversity and measures that can improve that environment, such as by returning it to a more natural state. There's one change that we proposed at submission, which is set out in our hearing statement to question 5, paragraph 2.510, in which the Environment Agency referenced that the plan didn't mention the River Tame water body, and we proposed a change to paragraph 6.24 to provide for this, and also added that where development is proposed adjacent to a chalk stream, early engagement with the Environment Agency is encouraged.
Yeah, we can probably just agree on those for effectiveness. Mr. Turnbull, any comments you want to make then on NE7?
It's more of a request, really. I know that we as a society have been in contact with the council before, and also the Conservation Board about since the local plan was published. There's been the chalk streams planning guidance produced by the Conservation Board. They appreciate it can't be policy and all that, but in 6.24 it sets out quite nicely about chalk streams and the threats they're under, and it would just be an opportunity to raise in that point that developers, people interested in chalk streams, to that guidance, that planning guidance, which covers DM matters quite nicely. And so it was just an opportunity to add that in there to heighten the profile of chalk streams a little bit more as well. So I know it's not directly a soundness issue, it's just a point to make there.
So that'd be change the supporting text just around sort of context and relevant guidance. Ms. Layden?
Yes, we're happy to take that away and have a look at it.
Thanks, sir. It's really, I think, possibly a point of clarification on NE7 to B. Avoid the need to abstract water from the ground, in particular from the rivers Ver, Gade and Bulbin catchments, which I find intriguing because this is where a lot of the potable water for the borough actually comes from now. It is extracted. So I'm beginning to, is this referring to the fact that individual developers should not have built boreholes or something like that? But I'm not sure I fully understand it, because this is where our water is coming from now. There are pumping stations alongside the River Gade, which, as you know, runs through the right through here. And so water is being extracted.
Again, it's contention. The start of it is development proposals, so it's proposals, and with that intention that, you know, any of those proposals that, you know, might be seeking to do that, you know, it needs to be taken into account, you know, the requirement on this. We recognise this delicate system here, and I think it's important that that is necessary in terms of local policy and effectiveness for the area. Yeah, there's not much more to add on that.
Can I just take that a little bit further, and I'll probably suggest a solution. I think when I read this, and Mr. Siegel, you've highlighted something that sort of passed me by in terms of the construction of this. I read B as effectively the same as seeing if there are there are opportunities for extraction of sand and gravel, saying if you're developing close to a river, maybe you might use some of that water during construction. I saw it more as that rather than inevitably, as Mr. Siegel says, because of where water is supplied in Dacorum, any new development that it has a tap will increase abstraction of water inevitably from those streams. So it's whether it's designed as I thought it was to mitigate construction, or more broadly to say that new development should take its water supply from elsewhere, which I don't think it can do. I saw this more as focused on abstraction during construction.
Thank you, sir. Again, it's probably worth us just going around and rechecking that point, probably with our DM colleagues, just to ensure the nature of that policy is striking the right balance.
Yeah, my point really is going to preserve or enhance the water environment to a more natural state. I mean, I agree with the policy, but going back, apologies for going over old ground, we're going back to infrastructure. We're not at the moment preserving those things at this present time because the infrastructure for the wastewater is not there. Even though the council have come forward from Thames Water saying that they can do, in particular for Berkhamsted, so many homes, the evidence isn't there because they're still tipping the water into the untreated wastewater into the canal and the River Bulbourne. The canal and the River Bulbourne intertwine, so it is one and the same. So they're carrying on to do that despite us going over this quite heavily in stage one. So I don't see there's anything in the policies where they're again proving that it seems, and from the developer's point of view, they are not really worried about it because it seems as long as Thames Water and the other infrastructure providers say, yes, we'll provide it, that's good enough, and we're still not seeing the proof of that. And in this specific instance, we're talking about a company that's servicing a £20 billion debt. Sorry, that's all my comment on that.
It's been covered at length, the impacts and the understanding of water, wastewater infrastructure with regards to, understanding the needs. We've discussed it and more broadly, but more specifically in certain areas to date, including at Tring. Quite happy to pick up the kind of site-specific kind of details around Berkhamsted in due course, but ultimately, the plan's been informed by a lot of consultation engagement. We've had some discussions about, the act and the legal duty and the right for people to connect, and also the balance to be struck between those water, wastewater infrastructure providers, how they can give any certainty right now, and just a significant number of outstanding objections in front of you, sir, with regards to the strategy and the growth.
And just perhaps if I can get a little bit philosophical, I'm sure this is something the council struggle with as well. I mean, we very much, very much aware of those points, and from it is a tussle in our minds, obviously, because we have policies which I think, Mr. Harbridge, and I don't want to put words in your mouth, you'd agree with what that policy says, but it's having the confidence that that will be fulfilled. So don't for a moment think that your point hasn't registered with us. It's trying to work out how far we can go down that route, really. But I very much recognise what you're saying. So thank you.
Okay, yeah, but I think you're right in terms of any 7 to B and just making that clear and effective. Ms. Thompson.
Thank you, sir. We're not seeking a change to the policy as such, but during the preparation of this plan, the Chilterns Conservation Board has produced and adopted planning guidance on the area's chalk streams.
You were out of the room
Excellent. Sorry, I was late, by the way.
Yeah, sorry, no, we did. I think it was literally as you walked in, we just finished talking about it, that yes, obviously, if that's guidance and it's relevant, the chalk streams are referred to, aren't they, in 624? So obviously the council said that, yeah, you know, as they do in the sporting sector for the ones, it would make sense to, you know, for context and background, refer to that. Mr. Turnbull, anything else on NE7?
Thank you, sir. Just under the first part, proposals will be supported where they conserve and enhance biodiversity. Our thinking more there is that proposals should be conserving and enhancing biodiversity, so they will be supported seems a redundant bit of wording there.
Which bit's redundant?
The first paragraph, number 1, proposals will be supported where they conserve and enhance biodiversity. I was just thinking along the lines of what the MPPF says, its proposals should conserve and enhance biodiversity. The supporting seems redundant. I know it's a missile point.
Yeah, it's probably, it goes to, could it be better worded? Possibly. I don't think it's a soundness point because ultimately the MPPF requires plans to be positively prepared. So I don't think that's a point of soundness, but it's a relevant point, it's a pertinent point. I just don't think it's necessary for soundness to change that. NE8 then, again, just in terms of the council, anything that you have seen or read where you think, yeah, we need to have a look at this policy?
Yes, there was one change that we proposed at submission, excuse me, to paragraph 6.27, related to the Grand Union Canal, and this reflects comments made by the Canal and River Trust in their Regulation 20 representation. And in particular, we suggested adding the words, the canal's age and methods used to construct its infrastructure make it vulnerable to damage from nearby development, and care must be taken to protect its integrity during works. So this would link to NE1, development proposals will be expected to protect and promote. So there may be occasions where nearby development might cause impacts on the canal infrastructure. There were no further changes to the policy at submission.
Ms. Denby, just to bring you in on this point, say there's a change I think we could support there just around effectiveness, but was there anything else in NE8 in particular that you think it should do that it currently doesn't?
Yeah, the inclusion of canal focus policy and the council's amendments relating to structural integrity are positive in terms of maybe there should be a reference to the MPPF and land stability rather than just doing construction, but that was a positive amendment there. We've obviously in our representations raised comments with regards to the needs assessment that's undertaken for moorings. And we think that there should have been more information that the Trust could have provided in relation to establishing the need for moorings in the area. And we do believe that, you know, there's an incomplete picture on what's happening in moorings in the borough. That's accepted within the assessment and also by the council in the further submissions. But in the absence of that analysis, I think that the policy NE8, or particularly maybe the supporting text, requires some further clarity, perhaps for future decision makers. Just in terms of, I think one of the key thing is the point 2 of policy NE8, which relates to developing the countryside. It says canal-based development. I think there just needs to be a little bit of clarity in terms of what that encompasses, because that seeks to, that canal-based developments will only be permitted in a mooring basin. I think, yeah, there's a clarity in terms of what that does and does not include. Particularly, it seems that, that moorings are separate from that. But when you read particularly, I think it's para 6.29, you can see how some confusion might come in future for decision makers with regards to that. There's also, just again, in terms of what that doesn't include, canal-based development. I mean, we're talking here in terms of facilities to support water activities, kayaking, fishing facilities, maintenance and management of the waterway, and even in a mooring basin, so they might not be in the area that's needed, and that might not be accessible to the trust or boaters who aren't, don't have a mooring within a basin. You also might need facilities to support moorings we call online, or not on the actual line of the canal rather than the basin. And then it kind of, that almost leads to, it might restrict those developments to larger scale proposals. The council's reasoning, I think, for that in terms of landscape impacts, visual impacts, but a basin, might have significantly greater impacts on the surrounding countryside than some alternative options for canal-based development. And there might be locations in the countryside where canal-based development and moorings, if that's encompassing that, would be appropriate, and they'd make a valuable contribution to the public enjoyment of the waterways, natural surveillance and the character of the area. And I think there needs to be that recognition that the character of the canal corridor can vary from other types of open space or landscape settings. And then just in terms of part 3 of that policy, in terms of the criteria, it says that what moorings must satisfy. In our opinion, we've talked about services, that whilst it's desirable to provide services, there are many moorings that operate and do not have all those services as described. At the Trust, we wouldn't always require full services, depending what's available nearby and the scale of the proposal. Obviously, boats can move to access services and facilities as well. And then just as an aside point, in terms of why the feel further clarity on these points is required, is in relation to policy NE 12, open land. When you're looking at those together, that seeks to designates all canal within the urban areas as open land. And then the policy says that proposals will be supported whether for sports, recreation, education, or other community or social uses. It doesn't mention residential moorings particularly. And paragraph 6.45 seems to indicate that residential utility services are incompatible with the designation. So where does that leave moorings particularly?
I think on the first point, I think I would agree. Criterion 2 in the countryside is there's internal conflict there with other policies in your plan and national planning policy. You could even delete the text. So it says in the countryside, adverse impacts are limited and carefully controlled, but still get you probably to the same place. I think I agree that sort of de facto sort of no to development just because it's in the countryside does sort of rub up against other policies. Even as far as, other policies would still apply, green belts, etc. So I think criterion 2 does need some thoughts, but I put it out there that I do agree with the representative that there is a conflict there with other policies in the plan, and probably a lack of justification, therefore it's unsound. The second point then, just in terms of how the sort of relationship with policy NE2, just talk me through how that would work. And I presume this is an example of being within an urban area, is that fair? In terms of this, that you said there was a conflict with NE12, would this be proposals within urban areas that would still be designated open land? Yeah. So I think firstly, so policy NE 8 criterion 2, I think yes, the council needs to have a look at that and there needs to be some change there. I just wouldn't mind the council's views on then how proposals for moorings and canal side development, how does that work in terms of its sort of any designation under open land and NE 12?
Thank you, sir. Just on the first point again, the point 2 of NE8, we will take that away. I think it's probably worth noting that the significant majority of that canal outside of the settlements is within Greenbelt, and just something just to keep in mind as we review that. Second point then, open land, in terms of NE12, open land relates to land within the built up area of our settlements. That's a designation that applies to, you know, land we consider should be kind of conserved in terms of preserved in terms of its openness, irrespective of its use. And that's only within the existing settlements. It doesn't apply more broadly outside of those settlements. So I'm a little bit unsure how that relates then to the designations that are adjacent to the canal side. I guess this is for new development or change of use of undesignated, including incorporating such areas into private currents. Again, I was a little bit unsure what exactly was being sought there in that context. Maybe again, if we can just have some clarity on that.
I think the point in terms of NE12 was the sport intake obviously designates the canal, say, within the existing settlements, and seems to suggest that residential is incompatible with that designation. So that was in terms of, you know, when you're looking at, so it rules out seemingly residential moorings in those existing settlements. It's just that. Paragraph 6.45. This is just there may be some uses that are incompatible with the designation, e.g. residential utility. So it's when it's referring to existing uses in those, in the open land.
Then we also have criterion 3, don't we, of policy NE12. Proposals to develop or change the use of undesignated open land. So you could, by inference, think that refers to residential moorings. I had one question. So while we're all thinking about that, on NE8, criterion 3, proposals for new moorings. Presumably it's not the council that has control over moorings. It's the Canal and River Trust that determine where the moorings go. The issue is not for a mooring per se. Is it not for development necessary to facilitate a new mooring?
Yeah, so there are certain moorings in terms of, you know, 14-day towpath moorings and leisure moorings that don't require permission. So it's maybe the residential moorings, I think, where the council would have that more control.
I think that maybe, again, I'm splitting hairs, but if we have a criteria that says proposals for new moorings must satisfy the criteria, presumably insofar as a local plan which deals with essentially land use can go, that would be development related to new moorings that could only be legitimately regulated. And I think I was seeing some nods there, so I think that's a tweak. Is it soundless? I'm not sure, but that's a tweak I think that needs to happen. Not result. So then we have the criterion, you know, a number of criteria. Okay, criteria A: not result in a proliferation of basins and/or lay-bys. And I understand the aim of this. Okay, well, you've got the kind of historic course, you've got the historic layout. You want to preserve that. I always struggle with the word proliferation. it does come up in a lot of senses in terms of proliferation of certain uses in town centres. I would encourage, if I may, again, the council just to look at what that is seeking to achieve. Is it because it's looking to protect the historic character, the rural character? What's the function of avoiding a proliferation of basins and bays? And if I mean, I suppose, what is a proliferation? Is it because you're looking to do the other criteria? Does that really need to be a criteria? Because anyway, you're looking at effects in terms of, other angles. That would be my challenge on that.
Thank you, Sarah. It's something we'll take away. Appreciate the point. It's trying to just digest the complexities of that right now and that relative to the others. As you said, I think you understand the rationale for it. I think it's about character, it's about maintaining character, I would say as well, and just being respectful to that. And I think while you may have one basin, it could very easily say, well, let's have a second or a third, because that's where all the existing facilities and access is provided. And I think it's just maintaining that sense of, that check on that it's not going to, have wider implications. But I see your point. We will check that.
My suggestion would be to reflect on whether you need to say it at all, actually, because there are various other criteria there. So integrating well with the landscape, historic and visual character, improving the canal management, etc. So whether you then need to set a threshold of, well, introducing some uncertainty as to what is a proliferation, I think that may run into difficulty. Okay, thanks.
Just going back to the NE12 point, does council know what it needs to do on NE8? Certainly around point 2 and maybe some of the criteria. Does NE12, and probably a question for Ms. Denby, does NE12 actually preclude or restrict moorings or associated developments alongside the canal? Because what the policy says is proposals to develop or change the use of undesignated open land will be assessed on the contribution the land makes to local leisure facilities, connectivity, townscape, the character appearance of the area, and nature conservation. So would that preclude the type of proposals that you're referring to?
My understanding is though that the canal is designated open land. So are you suggesting that moorings or existing moorings wouldn't be designated in that?
No, what your position is that the canal and some of the land around it is designated as open land. Yeah. And I think your concern, again, correct me if I'm wrong, I think your concern is that it would potentially, through policy NE12, preclude the development of new residential moorings. Is that right? Yeah. So where they require planning permission, that would preclude them. I'm just asking you, how would it preclude them? What parts of NE12 would preclude them?
In terms of that, it was more the supporting text in terms of the suggestion that residential is incompatible with that designation. And that the designated land will be protected. So by introducing, a proposal for an incompatible, something that's incompatible with the designation.
You're right in terms of what 6.45 says, but I'm not sure whether that's what the policy says, though.